again, it just tells the story of it's the evil and the ugliness of people's hearts these days is everywhere.
This is Franky Rose's Think Tank. Here's your host, Franky Rose.
Hey guys, welcome back to the Think Tank. Bright and early, are you guys ready for the Nicolas Mui to be sentenced? Sounds like we are going to have the victim impact statements first thing, and then we will get into sentencing after that. So that means that they could be bringing up the different victims, the other kids that Nicolas went after that day. You know, we could be hearing from parents, we could be hearing from siblings. It's just a heartbreaking thing. You know, what he did that day was absolutely brutal. 30 seconds of horror for these kids that were just tubing down the river. You know, watching the trial, we did see that the kids were being kids. They'd had alcohol in them, and they were, you know, being bratty, absolutely. But does that mean a death sentence? No, it shouldn't. Morning, Ruthie. Hope you guys are all doing well. We've just got a few more minutes here, and the court should be opening up. And like I say, we'll hear victim impact statements, and then we will hear what the judge decided. So I did take notice that last night, the ballerina case, the jury came back with a guilty. 11 o'clock last night. I didn't see that coming. So I'm unsure at this point if I'm going to do anything. Basically, everybody knows already. But I'll play it by ear based on what I see after we're done this stream. I also would like to, yeah, I know, Pam. I also would like to talk a little bit more about that UK attack where 3 little girls sadly died. There is still some of those kids that are not doing so well. And the same thing with the adults. 2 adult women were also attacked. And I do believe that one is still struggling. Isn't that something? They deliberated until 11 o'clock last night. I was shocked. Yeah, absolutely shocked. I didn't expect to wake up. I thought wake up to that. I was expecting to hear something today. So for them to come in last night, yeah, I was shocked. And it sounds like it was about 40 minutes before that verdict that they had decided that they were hung. Oh no, are they still, oh Lordy. Those, I don't know. They're going crazy over this. I was shocked when I seen, I mean, I don't know. Do you call that? I don't think that it's protesting. That's not what I consider protesting. Protestings are picket signs. They're not torching things. I'll take another look into that today, Ruthie, because, oh my word. So what I'm going to do here is I see that there is
the escalating
a
encounter.
little bit happening. We're just showing what happened
If there
that
was
day.
no
So let's take a
video,
look
how hard would that have
as
made
we're
your job?
waiting.
What would that
Yeah,
case
that's
have looked like?
rioting. Exactly, Ruthie. Yeah, what they're doing is rioting. Is it over and done with? Have they got
Fox
that
9
all
spoke to a
under
pair of
control?
jurors after the panel of 12, 6 men and 6 women, found Mui guilty on half a dozen charges. including
Oh, it's
first-degree
just
reckless
heartbreaking,
homicide.
Izzy. It's
I
just
feel that
heartbreaking.
justice was served.
The jurors asked us to conceal their identities, wishing to remain anonymous
Oh,
while taking us
Lordy.
inside the deliberation
Yeah,
process.
I'll take another look.
I spoke
It's
to one
just,
over the
it's
phone who
heartbreaking.
included Mui. Could have avoided the whole thing.
I mean, it's not like anybody was had a fence behind them.
So I'm going to,
Went, even if it was the wrong direction, he
I
walked
bet
away.
they are.
Felt like we put on a good defense.
Ugh.
But in many ways, self-defense is a community standard, and it's very dependent upon which
I am
group of
going
12
to
people
mute
within the
myself
community you
out.
ask.
They should
He
be
walked right past everybody.
in court
Went
any
back to his
moment
car.
here. We'll
Both
listen to
jurors
this and
reasoned if
we
Mui threw
will
the first punch, as several
see what the
witnesses
families have to
testified,
say.
he could not then claim self-defense.
You went to Mr. Mute, correct?
Yeah, I went to the guy who was punching people first.
Correct. Again, based upon your memory that he pulled someone's hair and punched them from behind, correct?
Based on the memory that I know that he punched someone, yes,
Okay.
it doesn't matter how he punched them. I know he punched them and he shouldn't have.
Prosecutors included a charge of battery, arguing Mui struck Madison Cohen first, sparking the physical altercation.
Why was it important to start your kind of deliberations or conversations around the battery?
The Madison Cohen battery charge was a really big thing for the whole case because what that basically amounted to is, who threw the first punch? We had more people that said that he punched her.
While there was little support in the room for Miu's claim of self-defense, I am told that 2 or 3 jurors pushed for a conviction on the intentional homicide charges.
But after looking at everything overall, I think it was just more of a freak thing. It was people in the moment. I don't think initially he had the thought of, I'm going to kill one of these boys or all these boys.
Do you think he hurt or helped his case by going on the stand?
I don't think he had much choice but to go on the stand. I think if he really was going to plead self-defense and have a case, I think he needed to take the stand to explain himself.
I lied about the knife.
Was that your knife?
Yes, it is. It was.
In this case, which I think is probably with a lot of cases, it actually hurt him. Just like I was saying, because the stories did not match. There were so many things that were not true that he said.
And back out here live with Debbie Lang, our local criminal defense attorney here in town, legal analyst, to help us walk through the sentencing phase today. Debbie, we talk about reckless charges. He was initially charged intentional, which would have been a mandatory life sentence, so he got spared from that fate. But he's still looking at decades in prison. Can you walk us through a little bit of some of the the windows on sentencing, the length of time in Wisconsin on these specific counts?
Yeah, and Wisconsin is different than Minnesota. So in Wisconsin, for the top count, the first-degree reckless homicide, there is a maximum 60-year sentence. However, the court in Wisconsin is required to bifurcate, which means the court is required to pronounce a specific amount of confinement followed by what's called extended release. People would think of that like parole or probation. And with that 60-year maximum, the judge cannot order 60 years of confinement. The judge has a maximum of up to 40 years of confinement, then 20 years of extended release thereafter. And if the judge were to go lower than that, for example, 30 years confinement, the judge could then do 30 years of the supervised release. With the battery counts, with the reckless endangerment of safety, that has a 12.5-year maximum. Again, have to break that down. The judge can go up to 7.5 years of confinement and 5 years of extended supervised release.
And then there are these 5-year escalators, because the jury was asked, did those crimes occur with a dangerous weapon? I mean, that would seem to be a no-brainer. It's almost should be part of the definition of the crime itself, but there is even an escalator on top of that, where the jury did say and answered in the affirmative when they read their charges back in April: guilty of reckless homicide, dangerous weapon, guilty of first-degree recklessly endangering safety.
Well, we should also note that there is also that misdemeanor charge there as well, and that can carry with it a maximum of up to 9 months in the local jail. It's not a prison sentence because it's not a felony level offense.
And would you expect Michael Waterman, the judge here, circuit court judge in Wisconsin, to really lay out why he's doing it when he's presents the sentencing? Would you expect sort of a rationale an explanation of what he does?
I definitely would. And a large part of that is I would think he would do that for the victims so that they are aware that this is a sentence that's being proclaimed because of what happened to you specifically. So I would definitely foresee the judge explaining why he's giving his sentence and giving sentences, of course, for each of those offenses very clearly so that each of those victims feel that they've been heard.
How would this case be taught in law school in the way consecutive versus concurrent? You know, it is one incident, but there are most definitely, you know, 6 victims, most severe, obviously being Isaac Schumann. But then down the list, there are 2 people who were significantly suffered significant stab wounds. 2 others, you know, more, you know, lighter pokes kind of thing, superficial, more superficial injury. And then of course, Madison Cohen, who's hit, slug, punched. Will the judge, I mean, would you be taught to sentence each individually and then put that on top and make you serve, kind of stack them all on top of one another? Or is it to be done concurrent, like kind of all one incident?
Yeah, so the judge is going to have discretion. The judge could decide to sentence the matter concurrently, which means that all of the sentences run together. Essentially, the largest sentence would be the umbrella that encompasses all of the lower or lesser sentences. I wouldn't foresee that here. I think the judge is going to sentence consecutively. So that means you serve one sentence for one victim, then the next starts, then the next. And so essentially that's stacking them on top of each other. And, you know, for your viewers, you would then add up all the numbers to determine how long is he going to be in prison.
Let's take a moment here. We've hit 8:35. We still don't see our feed up from the courthouse. Sentencing scheduled to begin at 8:30. I'm just going to speculate a little bit. I'm not necessarily hearing anything from our booth on it, but there is the chance that they've gotten started late for some reason, that there's some issues on the ground there. We haven't heard that. There's also the possibility that they're not allowing the camera to come up initially because, as I mentioned off the top, the victim impact statements are not going to be allowed to be on camera. So perhaps the judge wants to just get through that portion and we just haven't seen the camera up. So I'm not sure what we're talking about on that front just yet. I do want to mention a couple notes that we picked up on just from the public court filings. I did note that the defendant, Nicolas Mui, his legal team had asked if he could show up today in street clothes, civilian clothes. The state.
Oh, wow. They are not streaming the victim impact statements. Isn't that interesting?
Right. You don't bring an inmate in that case, because you could sway the jury or they could see something in his dress. But it does appear from the filing, the judge rejected that claim. So we will see Nicolas Mui in jailhouse jumpsuit while at the trial. We saw him, even though he was in custody and has been in custody now for 2 years.
And that's very common because, you know, the judge knows that he's been convicted and the judge is the one who's making the decision today, not a jury. So his attire isn't going to sway the judge one way or the other. And just practically speaking, getting those civilian clothes in to someone who is sitting in custody, having them change in and out, it causes more work for the jail. So I'm not surprised at all that the judge rejected that request.
And can we read into anything that it's kind of it's a slap at the defendant's request for some, you know, humanity or respect on this day?
No, I would say don't. Again, and it's because the judge, and I would have concerns if a judge was in fact swayed by what someone was wearing. And so this is the judge saying, you know, I'm going to be objective. I'm going to listen. I'm going to be fair. It doesn't matter what you're wearing.
We also saw that the defense has submitted its legal arguments. We talked off camera about what you think Aaron Nelson and his team might do today, because they know there is a high likelihood of a prison commit coming and a high number. So how do they spin their arguments? I mean, could they, in theory, show up today and, hey, you know, he's 54. This was not anything of his doing. Let's talk probation here. I mean, could we start it at that level, or do you have to acknowledge he's going to prison and maybe suggest a 10-year sentence with lots of community service on the back end?
I think they have to ask for probation based upon his attorney's statements and the clip that we saw. You know, he recognizes that there is a lengthy prison sentence that his client's looking at. But I definitely think the defense can ask for that. But they can also then say, in the alternative, judge, let's cap it at, for example, as you said, 10 years. So it wouldn't surprise me at all if they ask for probation. Realistically, I don't think that they would bet their house on that. I think they know that their client likely is going to prison here, or someone lost their life, there are multiple victims. So I think they know that it's going to happen, but they have to ask. And, you know, I would ask if it were myself. This is a gentleman with no history, his age, his family, his ties to the community, all of those components are important. And we're going to hear, I anticipate, remorse from him today. So talking about that remorse is going to be a focal point for them.
I want to ask you what the state will ask for. Will it be an automatic? Will the district attorney say this is a maximum case, sentence him to the top charge, top number on each count? But before I get your answer, I do want to let our viewers know that court has in fact begun in Hudson, Wisconsin, as we sort of suspected. And the camera is down because they have begun victim impact statements. And the very first impact statement is from Alina Hernandez. That's Isaac Schuman's mother.
Oh, my.
She had that heart-wrenching testimony, getting that phone call. She's out at a restaurant in Stillwater when she got a phone call from one of the boys tubing with Isaac that day that Isaac's been stabbed. It's about a 10-15-minute drive. She rushed to the riverbank, went into the wrong ambulance. It was just, she's crying on the witness stand, but everything she went through. I know she once upon a time was a single mom raising her 2 boys alone, really proud of where Isaac was in life. 17-year-old, started his own business. I mean, she's going to have a lot to say. I think it's a shame that they're not allowing victim impact statements because, especially Isaac, we have been outside of some news coverage. We haven't really gotten to know the young man. And today I know his family is going to provide that picture. So Alina Hernandez now giving her victim impact statement. It's about 8:40 now. So we're presumably about 10 minutes into this proceeding. So we're going to assume then the camera just never came up from the courtroom. I promise you we will get you out there just as soon as it does. Again, Judge Waterman not allowing victim impact statements to be recorded, to be videotaped. We have reporters in the courtroom, so we'll be able to get kind of the context of what these families say. But Isaac's mom certainly, that's a tough one to sit through, to watch, to listen, and a very difficult day for her. And this is 2 years now. This happened July 30th, 2022. So we're 2 years on. And
2 years exactly.
The case got slowed down for various reasons, but 2 years she's lived with kind of, now's her moment, and she's obviously delivering her impact statement at this point. With that, I want to get back to that question I had. The state's asked today. You gave the numbers, they're high, the 60 years, 40 confined, 20 out. Will they go for that? Do they have to acknowledge no?
What do you guys think? Are we looking at the higher end of things as far as a sentence go, or do you think that the judge is going to show some pity for Nicolas Mui and give him a lower sentence, not making it a life sentence for him?
Criminal history, that type of stuff, or do you see the state just saying throw the book at him, send him away?
Of yelling. And so I definitely think the state's going to come in and say this was such a young life that was taken and taken needlessly. So I think they're going to come in and ask for the 40-20.
You've compiled some stats. You did some reporting for me, and I appreciate it. As it relates to the first-degree reckless homicide conviction, are you in a position to kind of relay some of those numbers? It's really fascinating in terms of the number of convictions in Wisconsin under that top count. Now, this is very specific to the top count, right? We won't know what other charges unfolded with the homicide, right? Like in this case where we have other victims, but you have some stats. You want to kind of go through some of these numbers that I think our viewers would appreciate?
Yeah, it's interesting. So in Wisconsin, as well as Minnesota, you can request data regarding sentences that have been imposed for similar charges. And it's a very helpful tool for defense attorneys because you're able to look at historically, if someone is convicted of this offense, what sentence did they receive? You can also then look at their case, so the complaint, the charging document in the case, the indictment, to determine, all right, how are those facts different or similar from my case? And then you try to distinguish. And so here, I know statewide in Wisconsin, since 2003, there were just shy of 1,100 charges of first-degree reckless homicide or second-degree murder. The stats compile those together. And so it's 1,094 specifically. And 8 of those cases happened in St. Croix County, so the county that we're dealing with here for this case. Of that, 713 of that 1,094, they were sentenced. So those people either pled guilty or were found guilty. The remaining matters either pled to a lower offense, had the case dismissed outright, or they were found not guilty. And of that 713, Paul, 711 of them were sent to prison.
Oh,
So that means
wow.
only 2 received probation. So when I indicate that defense counsel should ask for probation, again, realistically, they know these numbers. These are great defense attorneys. They've done their homework. So they know that only 2 out of 713 convicted of this offense have received probation. So the likelihood's very, very low.
I'll say.
Additionally, when you shake that out, we know that 695 of that 711 received a sentence of 10 years or greater.
Wow.
And so the statistics don't break it down to 20 years or more. It's the 10. But we know that 695 out of 711 received more than 10 years of prison. So realistically, those defense attorneys know, and the state also could have done this research and could get that information to say, Judge, probation isn't something you should consider.
And, you know, again, differences between Minnesota and Wisconsin in sentencing, the sentencing guidelines, but it's almost in the statistics create the guideline here.
Right. And yeah, Minnesota's guidelines are much more strict in terms of they tell the judge, here's a very tight range. And that's based solely upon the criminal history of the defendant and the severity of the charge. In Wisconsin, the judge has greater discretion. They're not tied.
I'm with you, Pam. I'm thinking a longer sentence versus something short. It was horrendous what that guy did. I mean, I don't know if he snapped. I don't know what the hell. They say he's not typically an explosive person, but he sure was that day. And it cost someone their life. Everybody's going to be traumatized. I can't worry about Nicolas Mui's feel bads. He needs to serve, in my personal opinion, a top sentence.
To that small box. That's
ever had a defendant in front of him convicted of first-degree reckless homicide, so this is new to him. And what's interesting, I do think about is he has a jury, and you heard Aaron Nelson in one of the sound bites in my earlier story, kind of right if you joined us about a half hour ago, talk about self-defense being a community standard. So these 12 jurors found, did not believe his claim of self-defense. Judge Waterman, he may have his own personal opinions here, correct, of what he sees in that video or what happened that day, but he has to sentence based on what this jury found.
Right. Even if Judge Waterman felt that legally self-defense applied and he should have been found not guilty because of that, Judge Waterman cannot let that come into play and into his mind when sentencing, because the jury has spoken. The jury has found him guilty. The jury found that self-defense did not apply. So at this point, Judge Waterman has to focus on those 3 factors when sentencing, and that doesn't include whether or not he thinks the jury got it right.
Mm-hmm. Debbie, it's been 4 months since the verdict. I know one of the phases of this time period is what's known as a pre-sentence investigation, where they speak to Mui, they dig into his background, everything. Could you enlighten us a little bit on what might be in that report, and how does probation make a suggestion on a sentence, and Judge Waterman might reference it today in court? What's in that pre-sentence?
So there is another standoff in San Antonio. Holy crap, don't move to that city.
Investigation that we'll hear.
Please explain that a PSI, or a pre-sentence investigation report, it's a book report about you. And so it takes and looks at the defendant from the beginning of their life all the way through. So it talks about their family. It talks about where they grew up, their education, their history in terms of employment. It will talk about military service. It will address potential issues. So it will focus on chemical dependency issues, gambling issues, mental health issues, physical issues. It truly is a comprehensive report about the defendant. And it's designed to give the judge an objective look at the defendant versus what is being said by his attorneys as well as the state. So
I was going to bring it up for you guys while we're waiting, but it's gone dark for some reason. If it comes up, we'll watch that for a couple minutes and see what the hell's going on in San Antonio. Lordy, lordy.
And it can even include traffic offenses, one's driving record. It truly encompasses everything. And then there's also probation generally will reach out and ask the victims if they wish to provide any statements to the PSI writer. Here, I would expect that they would indicate that the victims plan on speaking at the sentencing versus submitting in writing through the PSI. And then generally, yes, probation does make a recommendation, but there have been times that probation merely states, here's what the law says. Here's what can be imposed, judge. These are the maximums. It's up to you.
Yeah, and there's 4 months of typical with that. It seems a little longer. I'm usually maybe a couple months, but we've stretched out 4 months. I know it's a significant case, perhaps just part of scheduling as well.
Yeah, I would think it's because of scheduling. Generally speaking, about 8 weeks is sufficient for that PSI to occur. And here the defendant remained in custody. So it does make it a little bit easier because probation knows where he's at and they can contact him and meet with him when it's convenient for them versus trying to schedule with someone who's out of custody. But 4 months doesn't shock me, especially given the severity of this offense and, again, the likelihood of significant jail time. If this were a misdemeanor offense, different story if the individual is sitting in custody, because you don't want to exceed that maximum and defense would be asking for less.
And just again, I would reiterate all through the the trial back in April when you guys were with us before was we talked about if he's convicted on the intentional homicide, it's life in prison, he's got to avoid that. He did, but in all reality, with the numbers that he's facing today, Nicolas Mui, he very much, this could be in essence a life sentence for the 54-year-old. I do want to reset the situation right now. So we're coming up on 8:50. Sentencing began roughly at 8:30. The cameras have not come on in the courtroom, and that is because Circuit Court Judge Michael Waterman is not allowing victim impact statements to be recorded, shown on television. Obviously, the courtroom is open. We have a crew, maybe even 2 reporters in the courtroom today, but we can't bring the victim impact statements to you live. So I'm here with Debbie Lang, local criminal defense attorney with Hallberg Criminal Defense, kind of walking us through the sentencing. And as we regroup, I think what we could do now for our viewers is we have the cell phone video, right? The 3-minute, 20-second cell phone video that was so critical in this case. It really defined the case.
It was the piece of evidence.
Yeah, absolutely. And it in a lot of ways divided the community because seeing it, depending on which section you look at, if you don't take it in its totality, you may come to one conclusion. Clearly, the jury came to another. You heard in my story a little bit ago, jurors never really, this group of 12 never went to the self-defense. So they clearly saw something in this video. So let's bring that up. That's Jawan Cockfield. That's a buddy of Isaac Schumann. He's tubing with him in the river that day. He's shooting on his cell phone camera. 3 minutes, 20 seconds. Let's go back, take a watch at that, and we'll come back with Debbie and see where we are from the courthouse in Hudson.
What is he on? Whoa! We up! What are you talking about? What the hell are you talking about? Get away from us! What? What's going on with y'all homie? He's on camera. Scripting. He's on 4K. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. The culture.
Brutal.
The culture. Who is that? Where's the culture? Who is that? Who the hell is this?
Bro, doesn't matter.
He said he was looking for little girl. He said he was looking for little girl. Yeah, that's exactly what he said. We're in the South. I even have that part on camera. What the hell is this guy's problem, bro? We trying to have fun. He's gonna close you. He's gonna claim you. We don't want this one.
Jeez. Look. Jesus, this man.
Oh my God! Oh my God! Oh my God! Are we serious? Is this real? Oh my God! Who is that?
Oh my word.
Oh my God! Is this real? Is this real? Oh my God! Oh my God! What the fuck? Is this real?
These poor kids.
That's not Bart! That's not Bart! That's not Bart!
Oh.
That's not Bart! That's not Isaac! Oh my God! Oh my God! This isn't real! This isn't real!
All right, 8:55 now. We've been sentencing going on in Hudson, Wisconsin, St. Croix County Circuit Court for about 25 minutes now. The reason why we can't bring you in the courtroom, a pre-hearing decision by the judge to not allow any camera recording, any broadcasting, any live streaming of victim impact statements. But I am getting our first set of notes from our reporters. We have both Karen Scullin and Bill Keller at the courthouse, Fox 9 reporters. Elena Hernandez spoke first. That's Isaac's mother, talking about Isaac's stolen life, and in losing Isaac, stole her own life. This is not, my son did not die in an accident. He was killed by an evil monster.
Yep.
Continuing, she hopes this monster suffers every day until he goes to hell. Her words there.
Whoa.
Again, a reference to monster, wishing him a trip to hell. She does ask the judge to sentence me to the fullest, which we've talked about now, just on the count alone for Isaac. That's 40 years in prison, 20 years on supervised release, and then potentially, although maybe unclear exactly how that 5-year escalator works, but she's asking for a big number there. We also now know Donnie Hernandez, so that's Isaac's stepdad. He was basically raised by Donnie Hernandez. Donnie Hernandez also giving his victim impact statement, and I understand now we were an aunt as being allowed to speak, talking about Nicolas Mui's choice not to walk away from the encounter with the teenagers, that the loss of Isaac very much impacted her life as an auntie, and that she would do anything to get justice for Isaac, and that she is in weekly therapy because of what happened that day. So again, not surprising, some of the verbiage or some of the statements coming from Isaac's family. This is their moment. This is their time to speak. And clearly they are opening up, and it doesn't sound like, I don't want to speak towards the forgiveness or anything like that, but clearly they are seeking the maximum here.
Absolutely. There's no question. I mean, we saw from the testimony of Isaac's mom, just the pain that she experienced in losing her son, the pain in terms of the involvement, seeing what she did on the banks of the river, and then, every day she's without her son. And so it doesn't surprise me at all that these are very powerful statements that are coming from Isaac's family.
Yeah, just a little bit more. What about Isaac's dream? Asks the family. He's the most beautiful young man, wanted the best for everyone. Blessed to raise him as my own child, meaning, stepdad there, and be called dad by him. Again, just reiterate, I know a little bit about Isaac, and that he was a 17-year-old junior. He loved golf. His parents live on a golf course out there in the Stillwater area. He had started his own business, like detailing, cleaning cars, and then boats at the marina on the river. Engineering. I think I seem to remember Elena mentioning at one point had dreams of maybe attending college at Madison. I know the family has subsequently begun a foundation in his name, the Isaac Schumann Foundation. In fact, one of their annual fundraiser to raise money is coming up on Monday out at the golf course in Stillwater. They're raising money for scholarships for kids who basically have entrepreneurial dreams like Isaac did. And obviously the tragedy is unfolding in that courtroom. I think it's important to share in the context of everything we've experienced with allowing us into the trial, but the judge has spoken on this front.
So what I'm going to do is pop over, and we just got an update as far as what's going on in San Antonio now. So we'll listen to this.
She just blocked our entire anything, right? Okay.
Oh, just horrible. Just horrible. So this is happening in San Antonio right now. Get a little bit of an update while we're waiting.
Okay, this should be up next.
This started about 3 a.m., I do believe. I think it started out with a hooting.
Okay, she's rapping with her. Intro. Okay, got it. Well, they've moved us back a second time. Let me step out of the way here a little bit. You can see police kind of conferring right here. There's detectives out here. We have a drone shot up here. And this has started out as a deadly shooting, and then it has now become a standoff situation. What we know is that this all happened and unfolded just before 3 o'clock this morning here at Hawthorne Woods. This is off Lock Hill, Selma, near De Zavala. And what we know is that there was an Airbnb. There was apparently some party going on. This is according to police at that Airbnb. Several shots were fired. Several people called police saying
Good God.
gunshots were fired. Then they found the victim when they got here across the street in the driveway. They say it was a man in his 20s. He was shot several times. They say everybody scattered when those shots were fired, as you can imagine. And they believe that they have one or as many as 4 people holed up inside that home where that party was. And so as a precaution, they told us, with new information, they moved us back a second time, even further back. We have a drone up now. We have police on the scene. We have crime scene investigators, and we have detectives out here as well, just trying to get those suspects, or possibly more than one suspect, out of that home. They say it's an active situation. They do believe he has a weapon on him, but that's all the information we have right now. We'll continue to stay on top of this standoff situation, this very active scene, and bring you more details as we get it. I'll also be updating my social media pages, and you can check online for a live streaming shot of this as well, although there's not much to see since we've moved a second time. As a precaution, they say it was a matter of safety. We will bring you updates as we get them, and this live stream will stay up for as long as we can keep it up as well. Reporting live on the north side, I'm Christina Delgado. Send it back to you.
Lordy, lordy.
Important for some closure, as you said, in terms of this chapter. The appeals generally are things that, of course, they will keep up on, they will be made apprised and aware of, but it's not that they're going to have to testify. They're not going to have to do that at the appellate level. And so for them, hopefully they can start moving forward and continue their journey of healing.
How important, I know every family is going to be different, but is that number, do you find when you're in that courtroom? Are there, do people put a certain number on justice, the number of prison years? Will this family come out of court, their mood very much depending on what Waterman hands down?
Well, I think the state would have prepared them. And the reality is there is no number that will bring their son back. There is no number that will take away that pain. And so the state would talk to them about the fact that, yes, we are seeking the maximum. Again, that's what I expect. But the reality is whatever number it is, he was convicted. There has been justice for Isaac. And so, if of course the judge were throw the Hail Mary and do probation, I definitely think there would be a lot of anger and hurt. If the judge does something less than the 40-20, I would expect to hear that they are disappointed with that, but they should have been prepared for that.
And again, to that point, is that a jury found him guilty, right? That as Aaron Nelson, the defense attorney, had said, self-defense is a community standard, and if the family takes anything solace or whatever it may be, a jury of 12 from that county, St. Croix County, Western Wisconsin, they found him guilty of a reckless homicide charge and made clear, at least subsequently in my reporting, that they never really considered self-defense. They just did not believe that guy. So the court system, the justice system has spoken in that sense.
Absolutely. And for the family, for the jury to disregard self-defense, to them that means, you know, their son, and no one deserves this. But when the jury says this wasn't self-defense, for the family, their son didn't deserve this. This isn't something that he initiated or that his conduct caused. And so for the family, they definitely would hold on to that, and that's important to them.
And this is an interesting development from court. A.J. Martin is giving a victim impact statement right now, per my colleague Bill Keller in the courtroom. Talks about him clinging to life, the breathing tube. We know he had to be resuscitated, that the medical teams working on him in the immediate aftermath of that stabbing, July 30th, 2022, had to revive him a couple of times. The scars hurt all the same. He's very self-conscious of the scars on his body. That's, again, another compelling victim impact statement to hear directly from A.J. Martin. I mean, and we heard, you know, some of it during, his testimony, his talking about what his injuries, and then, yeah, he very well, there could have very well been two deceased victims that day, but A.J. Martin now speaking in that courtroom.
Well, that's interesting because I could have seen the state choosing to put AJ last because in terms of the severity of injuries, obviously the deceased is the most significant, but AJ Martin's were next. He was the gentleman who essentially was disemboweled. He had the large scar on his abdomen. As you said, he had to be resuscitated. So I could have seen strategically the state choosing to put the two most significant of injuries, the beginning and then at the end. So they haven't done that here. So I will be interested to see who's next. Is it Ms. Madison? Are they going to go in descending order and then concluding with Ms. Cohen? Or are they going to jump around a little bit?
Yeah, we'll see. We just don't know. The district attorney's office didn't provide us with any rundown. AJ could be the only one who wants to speak in person, because at least I was getting some indication from some reporting from some courthouse sources that perhaps we wouldn't hear from any of the victims. So the fact that AJ Martin, what I don't know, just because the way the notes are coming in from our team, is if he's there physically in person or if he's delivering his via Zoom, because we do know some victims are being allowed to attend this hearing via Zoom. And here's a direct quote, again, AJ Martin, one of the stabbing victims, quote, "I was gutted and died for 9 minutes. 9 minutes. It was straight out of a war movie." They said how the doctor, that's how they said, doctors described his injuries, was straight out of a war movie. So he's going there. He's telling him his impact on his life, and presumably his victim impact statement will close with a plea for the maximum.
Absolutely.
I don't know, the defendant, he's probably got some thoughts on what eventually he wants to say today.
Oh, yeah.
I can't imagine like he's figuring how to weave stuff into what he's going to say based on what he's hearing now, right? I mean, obviously the attorneys have the wherewithal maybe to take it all in and process this, but it's a tough time on your side of the bench in this hour of victim impacts, isn't it?
It is, and I would anticipate that in fact Mr. Mui has his statement written out, but the reality is he's human. He's hearing this, as you had indicated. We're receiving reports that he's wiping his face. There's no way he could not be impacted by these statements. So I wouldn't be surprised, even if something is written out, I wouldn't be surprised if he goes a bit off script just to address some of the things. And it may be as simple as just extending apologies directly to those individuals who are present or who are there by Zoom versus an overarching umbrella apology. So I would think that he likely will go off script a little bit, but it'll be a small amount. His defense attorneys want him to stick to the script because their arguments are going to be based on that, and their arguments are going to be focused on his character, lack of criminal history, and hopefully his remorse for what his actions caused.
I'm bringing our viewers up to speed here, coming up on 9:08. We've been inside the Hudson courtroom, St. Croix County Circuit Court for about, coming up on 40 minutes. We're in victim impact statements. The judge not allowing these victim impact statements to be recorded, shown, live stream. We have reporters that are feeding us notes. I can clear up at this point, A.J. Martin, he was in person, again, disemboweled, dead, 9 minutes. Doctors describing that he was a victim that basically came right out of a, quote, war movie.
It's more powerful in person.
Yeah.
So I would think,
strength.
absolutely, I would think the state would encourage them to be there in person. But for some, it may practically be an impossibility simply because of scheduling and travel. And for others, they just may not want to go back into that courtroom where they had to tell their story. But the state would definitely try to get them there live.
That's a good point. I do want to just another news development. Riley Madison, the second sort of most significant injured. We had done the story with her at the time from her hospital bed as she was recovering. Madison Cohen's friend, she gets stabbed. I don't remember the exact details in terms of the injuries, but certainly had some significant internal injuries that created some lifelong impacts on her. She is giving a victim impact statement via Zoom. So she's the first one via Zoom, and A.J. Martin thus is not the last victim to provide a statement. Every conversation, this is Riley Madison speaking, every conversation I have, I always circle back to that nightmare, meaning that day, July 30th. She's jumpy now, hyper vigilant. She says it is just living a life of exhaustion because of kind of her experience and the nightmare she's has had to endure because of what happened to her and obviously her friends. Now, important to note here, just for those of you perhaps not totally familiar with this case, this group of people who were stabbed, A.J. Martin's, the Carlson group, we came to know them, Dante, Tony Carlson, Riley, A.J., they didn't know Isaac Schumann and that Stillwater group of teenagers. Those two groups were tubing separately that day on the Apple River in western Wisconsin. But what had happened was that commotion started between the Stillwater boys, Isaac Jawan, Alex Vang, some of the others in that group, and Nicolas Mui. They kind of heard the rising volume. They were concerned. And that other group then came over. And that, I know they came over to help. And I know we talked to your colleague, Marsh Hallberg, back at the time during the trial about just the what if game and if people had just made different decisions. The Carlsons come over at the behest of the dad, and I'm blanking on his first name, but that he had encouraged his sons to go over, Dante and Tony, to help. And really they ended up escalating. Madison Cohen certainly helped escalate. She thought she was just trying to get Miu away. And just a lot of what ifs.
Yeah, and that's something that they're all going to think about that. Mr. Miu is going to think about that. But you can't rewind. And so here, had that group, instead of focusing on Mr. Miu, had they turned and focused on the boys to try to bring them down as they were yelling different things, it may have been different.
And Debbie, with that, we are told Riley Madison was the last victim impact of the day. So the camera feed has just come up, 9/11. So we got about just less than 45 minutes of victim impacts. We are getting our first look at Nicolas Mui. He is, as I suggested, in orange jailhouse jumpsuit. There he is on your screen. The defense had made the request to give him some respect today, let him come in civilian clothes. The state fought that. The judge ended up rejecting that request from the defense. So he's in orange jailhouse jumpsuit. His head is bowed. Our reporter said it's been bowed through all of the victim impacts. Let's see if the courtroom audio is up.
We talk about this 30-second incident. But I think it's important to remember, too, the only reason he was by this group was as they were floating away, after he was insulted, he charged up onto the boys and grabbed onto their tube. I'm going to start by talking about the seriousness of the offense.
Are you going to project on the monitors?
Yes. I just have a exhibit labeled Exhibit 1. It just has 2 photos on it.
You ready?
Yes. Obviously, a homicide, any homicide is serious. In this case, Nicolas Mui killed 17-year-old Isaac Schumann. There's very little I can say about the effect on the victims that hasn't been said or expressed better by his family, both at trial and today with the victim impact statements. What part of what makes this so tragic and horrific is how easily Nicolas Mui could have avoided all of this. As I said, after he was insulted, he could have just let the boys float away. Instead, he charged up onto them. When the boys were yelling at him to leave, he doesn't. When another group comes to intervene to help to yell at him, tell him to leave, he doesn't. Instead, while multiple people are telling him, pleading with him, yelling at him to leave, he's smirking and he takes out his pocket knife. The defense filed a memo that presumes that Nicolas Mui actually believed his life was in danger, and that belief was just unreasonable based on the verdict. I don't think that's the case. I think the evidence shows he snapped, as we argued to the jury. I think that's evidenced in his attempt to flee afterwards to avoid responsibility, and his washing the knife, ditching the knife, saying nothing to his friends and family that were there. His playing dumb with Sheriff Knutson when he's first apprehended, acting like he didn't know what happened, saying he saw what looked like kids being kids. Maybe they were fighting. I think it's shown by his countless lies in his interview with Lieutenant Hart. As he's standing there smirking, as we all saw in the trial and the screenshots and the video, holding his knife, he never raises his knife. He never says, "Get back," like any reasonable person would do if they're afraid. I think anybody who's studied self-defense statistics whatsoever knows how many potentially violent situations are diffused simply by somebody pulling a weapon if they feel threatened and saying, "Get back, I have a weapon." He didn't do that. He held it down by his side where nobody saw it. After he took out his knife, when there's just two small females standing in front of him, he then punches Madison Cohen in the face, starting the physical altercation. It had, up to that point, been strictly verbal. Understandably, unsurprisingly, after he punches a barely 100-pound female in the face, he gets hit back, and he gets up and starts stabbing anyone within reach, regardless of their role, what they're doing. Riley was just standing there, as witnesses testified. Even after his friend Ariel was there, even after he'd stabbed multiple people, even after AJ is disemboweled, trying to hold in his intestines, Nicolas Mui, instead of going back to his group, walks away from them, up to Dante, and stabs him in the chest. There's nothing that shows other than vengeance, because Dante had punched him. So he was going to get even. And then clean the knife, ditch the knife, and return to his group. He encouraged his group to leave. He never called 911. He never tried to help any of the victims. He casually floated by the carnage that he left. Members of his group saw people getting CPR. But for the prompt response from the Sheriff's Office, Somerset Police Department, AJ likely would have also died, also but for the medical intervention. But for the prompt response from law enforcement, Nicolas Mui might have gotten away. He tried, once he got to the exit, tried to walk past the first officer. It was only because of the video and the screenshot that was circulated by law enforcement and witnesses that he was found. Because law enforcement thought they were looking for a single person, shirtless. Mui had changed his appearance, put on clothes, hat, sunglasses, and tried to just disappear with the crowd. In his interview, he made up many bizarre lies, some of which I think show his own state of mind, including his own recognition that he should have just left, because he specifically told Brandy Hart, Lieutenant Brandy Hart, "They told me I couldn't run away." Obviously not true. That's what they were begging him to do. He said, I don't know why they wanted to scare me with knives. Not true. He was the one with the knife. He said he absolutely did not have a knife. Obviously not true. He feigned to not know the state of the other people. When he was told that 4 people went to the hospital and 1 was deceased, he said, oh no, as if he didn't know and he hadn't floated by the carnage that he created. The river was running red with blood. AJ's disemboweled and he pretended to not know. The defendant's actions, as we've heard today from the victims, affected so many people beyond Isaac and the other stabbing victims and Madison Cohen. It affected his friends, his family, classmates, teachers, the friends and family of the other victims, innocent bystanders around the river, the sense of safety in our community, and what's otherwise known as a recreational area. We heard from the victims earlier the lifetime physical damage as a result of this for AJ and Riley. There's obviously a lifetime emotional damage for all of the victims and family. Dante and Tony were lucky, no vitals were injured. Madison Cohen, for the battery, her injuries were pretty minor. It was pain, essentially. But she talked to the PSI writer about the emotional trauma from this event, as we've heard from other victims this morning. When we first met with Madison, she told us similar things that she told the PSI writer, that about how when she got to shore, Isaac, who she didn't know was there getting CPR, and that Isaac's mom showed up. And Isaac's mom was holding his feet and saying he's going to be okay and sobbing. And Madison, sobbing, telling us this, said she decided she's never going to have kids because she can't stand the thought of suffering trauma like she witnessed with Isaac's mom on the shore. Proper consideration for sentencing, as outlined in Galleon, is the character of the deceased in a homicide. We've heard about Isaac from his family. His mother also provided us with some letters from other friends who aren't victims, describing what kind of person Isaac was. His friend Alex Vang, who was with him on the river, described him as always wanting to make sure everyone was happy, always cracking jokes, generous, talked about how they'd spend times talking about their dreams and goals after high school. He said Isaac was one of the people who inspired him for his future because of how driven and motivated and energetic Isaac was. Talks about anger, grief, and guilt following this incident. Landon Wire, who was with Isaac, talks about how this has affected him, loss of one of his best friends, about how he'll be scarred and traumatized by seeing the blood, the guts, and losing his friend, about how he'll never get the chance to grow because of the actions of Nicolas Mui. Juan, who filmed the video, hopes that justice will be served and his conviction is a step forward, but talks about how he'll never replace being able to see Isaac again, having one more hug, telling him he loves him. Isaac's girlfriend, who he'd known since middle school, talked about how they were looking forward to the future and what kind of house they would buy. Described Isaac as hardworking, intelligent, caring, charismatic, funny, and loving young man. As she knows he's protecting her and his family now. Character of their defendant is also relevant for sentencing. The defendant's 54 years old. As the PSI talks about, he came here from Romania when he was 15, worked as an engineer, had no criminal history. He's been divorced 3 times. He has one son who lives in Romania who he hasn't seen in 10 years. One odd thing from the PSI I noted is he spoke very highly of his dad and denied any abuse from his dad. But there's a public restraining order where he and his brother said that they're abused by their father. I don't know how relevant it is, just a little bizarre discrepancy I noticed. He talked a lot about his own struggles, about he's depressed and his health issues. In the PSI, he talked very little about the effect of his crimes. And that's been a present fact throughout this case, is no remorse from the defendant. You'd think, one would hope, even if he truly believed this was self-defense, he would at least feel sorry that somebody was killed because of his actions. There's been no evidence of that. At trial, he was only emotional talking about his dog, never emotional about the horrific injuries or the death of Isaac. I'm sure his attorney and maybe even himself will talk today about how remorseful he is. I think that rings hollow. Every defendant claims remorse at sentencing. What's much more enlightening about how he truly feels is how he acts, what he said leading up to today. All he really mentioned in the PSI that would suggest remorse is he's very sorry for everyone involved. No specific mention about killing Isaac Schumann, a 17-year-old, or the loss of Isaac for his family. Throughout trial, the heartbreaking testimony of Elena and the other witnesses and victims, there's no emotion from him. And I believe his true feelings are evident in his calls with his brother. He has numerous jail phone calls with his brother speaking Romanian, or perhaps he was a little less careful about what he was saying because he thought maybe it wouldn't be translated. He has a tendency, well, one, he consistently disparages the boys. He has a tendency to refer to them as other than human. And defense can correct me if I'm wrong, there's never any hint of remorse for his actions. Instead, I'll just read from one section. He says, "At jail, these bastards got me here. Well, it is what it is, but at least I'm alive. I was able to fight in order to survive. You got it? At least I survived the attack. And now look, the bastards are free. The bandits from hell, they are free, and I'm here. I'm victimized again." No, the bastards are free, and I'm here. No acknowledgement whatsoever that Isaac is not here. He killed Isaac. I'm sure there's going to be a large attempt to paint him as this great person. His jail phone calls, I think, tell a different story. He refers to Lieutenant Hart as a dirtbag policewoman, that wretched lady, suggests she's hiding evidence. The common theme is throughout his calls, he can't accept any personal responsibility. He blames Lieutenant Hart. He blames his own group, including his wife, for not stepping in. He also can't stop lying in his phone calls. He maintains there's other knives. He maintains with his brother, even well after he's arrested, after he's seen evidence, that he didn't take out the knife until after he was attacked and down in the water. That is undeniably untrue. You can clearly see him in the video before anything turns physical, smirking and holding that knife with the blade open. He claims he didn't try to leave the scene, claims he tried to run away from the confrontation. His continued lies, no, even he knows it's not self-defense. He didn't think it was self-defense. He knows it's absurd when if somebody looks at all the facts, to claim self-defense, so he continues to twist him, even with phone calls with his brother. as well as that section I read where he described the boys as demons from hell, he describes them as baboon bastards. But most often he refers to them as bastards. At one point, expressing frustration that his wife and friends didn't get to help him to get a little bit more insight into his thought process. He says, friends, but when it's about a fight, they don't come to intervene. Man, had it been Sandy in that kind of situation, surrounded by those guys in the water, I would have rushed there terminating those guys. There's so many, like you said, it would have been more of them like that, bellies up. So that's the cold and callous way he refers to killing Isaac, as leaving him belly up. Obviously, he's still angry. As we argued in the trial, he was angry at the time, he wasn't afraid, and he's still angry and accepts no responsibility. Clearly has no idea that self-defense is meant to stop a threat, not to terminate people and leave them belly up. I'm sure defense is going to spend a lot of time talking about his lack of criminal history. It's not unusual we see horrific crimes committed by somebody with no criminal history. I'm sure there's going to be a lot of discussion about him being a peaceful person. A peaceful person doesn't rush up on a group of teenagers because they insulted you. Doesn't refuse to walk away. A peaceful person doesn't take out a knife when they could have just walked away. Doesn't start a fight and stab 5 people. I think there's more. A big question in this, I think defense is going to argue, is he's not a danger to the public. One, I think the crimes speak for themselves. Clearly, he's a danger. No reasonable person in his situation would have acted like he did. This would have ended before it was even anything. Talking about leaving people belly up and terminating them is not the words of a peaceful person. His lack of remorse is certainly an indication of his lack of respect for human life. His dehumanizing the boys, including Isaac, with this terminology he uses to describe them. Another thing that's perhaps a clue that maybe this shouldn't be that surprising is when law enforcement went to his residence after he was arrested, they got consent from his wife to search his Jeep. In that Jeep, they found a machete concealed. Can we have the screen? That was concealed between the center console and the passenger seat. When law enforcement asked his wife about it, she said, described that he has that for protection from possible road rage incidents. She then later said, well, actually, maybe it's from camping. I think nobody hauls camping material, camping equipment concealed where it's in easy reach of the driver.
Jesus.
It's absolutely bizarre that somebody would decide, one, that they're so concerned about road rage that they have to carry a weapon. I completely understand people conceal carrying, but to do it specifically because of road rage is strange. But absolutely bizarre is choosing to carry a machete. That makes no sense to me. It's not a defensive weapon if he's attacked in a car. It's only an offensive weapon because he'd have to get out of his car. The state's recommendation is a total of 60 years initial confinement. For count 1, for the homicide of Isaac, the state's recommending the maximum sentence of 45 years initial confinement, followed by 20 years extended supervision. For the recklessly endangering safety, counts 2, 3, 4, and 5, state's recommending 6 years initial confinement, followed by 5 years extended supervision. And on count 6, the battery, the state's recommending 1 year, with all counts running consecutively. State believes a lengthy prison sentence is appropriate to protect the public. It's appropriate as punishment. I know defense is going to talk about that a lot. The reality is that's a proper consideration, whether they like it or not. punishment is a consideration in sentencing, but mostly to not depreciate the seriousness of the offense. It's hard to put into words how graphic and horrific this was. Everybody saw the evidence at trial. The public didn't see all of it. Some of it we kept or tried to limit what was shown because it was so graphic.
Yeah, he's lost a lot of weight.
The only other thing, Judge, is the state would ask for 30 days for restitution. I believe there will be some, I'm hopeful that we could reach an agreement, but if not, we'd ask for a restitution hearing.
Is that all?
Yes.
Why don't we take a short recess? It seems to be a logical place for a break. We'll come back at 9:45. Mr. Mui and his attorneys will be escorted to the waiting room. We'll reconvene in 10 minutes.
All right, taking our first morning recess, 9:34. So we know we had to rejoin the courtroom late, and that the victim impact statements were not allowed to be shown on camera, but everyone in that courtroom has now been seated there. Some intense, obviously, victim impact statements, and now the state has made their ask for what they want to see Nicolas Mui sentenced to, and they are, I mean, it's not a full maximum ask here, but certainly
Very close.
would amount to a life sentence for a 54-year-old, 40 plus years for Isaac Schuman's death, another 24 years initial confinement, meaning prison. You do that amount of time, so 24 plus at least 40 there, 64, another year for Madison Cohen. I mean, you're getting up towards 70 years in prison in all. We're not exactly sure. He may have misspoke a little bit about a 5-year. There's some confusion in the math, but certainly upwards of 70 years is the ask of initial confinement, meaning the time you do. Your thoughts as Debbie Lang, local criminal defense attorney, joining us for some legal analysis. Debbie, your thoughts on that request?
Not surprised at all. Not surprised that the state's going big, and not surprised that they're asking for consecutive sentences. So sentences that run one after another, not on top of one another. So the fact here that they're asking for the maximum under the law in Wisconsin for Isaac Schuman's death, and then the state came and asked for a bit less than the maximum they could have for the endangering of the other individuals. They could have asked for up to 7.5 years confinement for each of those counts, and instead they asked for 6 years confinement on each, followed by 5 years of supervised release after Mr. Mui is released from prison.
Was that a pretty standard argument from a prosecutor in a case like this? I mean, he quoted from what we talked about, the pre-sentence investigation, meaning sort of a full in-depth investigation into the defendant's history, in this case, Nicolas Mui, citing a lack of remorse. He had some very disgusting language, frankly, about the boys that he encountered that day, the crowd, the tubers, a lack of remorse. I mean, we saw the machete at the end that was kind of found in his vehicle after the incident. But was that a pretty standard argument that you would see at sentencing?
Yeah, as anticipated, he hit those 3 points that the judge has to consider. The judge has to look at the nature of the offense. That's where the prosecutor specifically discussed the horrific nature of this offense, the fact that Mr. Mui tried to conceal his identity, didn't render aid, tried to hide the weapons, the lies. That's all focusing on the nature of the offense. Then he moved into and spoke about the character of the defendant. In that, he pulled those jail calls. All calls when someone is in a correctional facility, they are recorded, and they can be pulled by law enforcement or the prosecutor, and one doesn't have privilege with those calls if they're speaking to someone other than their attorney. And so we did hear very powerful and, as you said, shocking language that was used during those calls when speaking with his brother. So the state focused on that to attack Mr. Mui's character. And then finally, They spoke about need for protection of the community. That's where the machete comes into play, and why that machete is in a vehicle that Mr. Mui is driving about in the community when he's encountering other individuals, right at arm's width to be able to grab and use. And according to his wife, at least her initial statement, he had that for concerns about road rage. So all of the arguments fell into one of those three categories that the judge has to consider. So it was well structured in that regard.
And as for the machete, we could talk a little bit about it, given your legal expertise here. Is that machete was subject, I did mention it during our trial coverage, it had become a point of emotion during trial.
Yeah,
The defense
about 7 minutes,
preemptively
Christy.
said, machete's not coming in at trial. And the state didn't necessarily try to introduce it at the trial, but they knew it was in the investigative file. They wanted it out. So it never came in. Jury didn't see that. Had nothing to do, obviously, with the encounter itself. But here at sentencing, books closed, you're showing the judge everything, you're putting everything on the record. Now the state brings it in.
Absolutely. And here the state is allowed to bring it in because, again, it's going to address potentially one, if not two, of those sentencing factors. So the importance of protecting the community with a sentence, as well as the defendant's character.
Couple points to make. Again, we kind of hopped in. We lost the victim impact statements. That was a judicial order. That was not a decision here at Fox 9. Judge said we could not record and show the victim impact statements. But once the camera came up, we talked about Nicolas Mui the defense had made a request to let him show up today. Civilian clothes. The state objected, and clearly Judge Michael Waterman said, yeah, you show up under the current policies and procedures of the jail. He's in the St. Croix County Jail, has been for 2 years. He was never able to make bail, but the judge did revoke any chance of bail after he was convicted. So he's been in jail, and policy and procedure there, orange jailhouse jumpsuit, and you'll even see he's handcuffed and shackled at the feet. So he's sitting there observing this, taking this all in. As far as our reporters have said in the courtroom during the several victim impact statements, we heard from several members of Isaac Schuman's direct family, mom, dad, stepdad, an aunt. And then we heard from a couple of the victims who survived, AJ Martin, who's in the courtroom. You could see him behind one of the camera shots. And then Riley Madison apparently provided her statement via Zoom. Now we turn the page to the defense. When we come back from break, it'll be Aaron Nelson and Corey Girafasi's opportunity to rebut that, ask for what they're going to ask for. So this is you. This is Debbie Lang. You've done this a gazillion times. What are those two attorneys doing right now as they prepare to make a counter argument for what they think that you should face?
Well, they've submitted some arguments, and they have submitted some letters that attest to their client's character. So I would anticipate, they're not going to read those, of course, because they trust that the judge has done that. Instead, they're going to be pulling key components out of those letters, focusing on those. I definitely believe that they are going to have to address these jail calls in some way. That the argument of the state, that's not the first time the defense has heard of this. They would have had to have been put on notice. And so they're going to be prepared to address that. Also, as you saw, both defense attorneys were taking notes while the state was presenting their argument. They're not going to hit on every single point that was raised by the state, but they'll certainly pull out some of those to try to, again, address those three characters that need to be discussed during sentencing and try to dampen the effect that the state's arguments had. And Paul, I do think it's important to note, just for your viewers, that when it comes to a defendant who's in custody, being in the orange and being shackled, that's standard. So even if someone is in custody for a property offense, they're still going to be shackled as well. That's not an indication that the judge feels that Mr. Mui is a greater danger than anyone else. So I think that's really important to point out, that it is standard. And again, for a jury, they would have no reason to know that. The judge, of course, does.
And during a trial, you wouldn't want that, whatever that imagery creates in the mind of a jury, you wouldn't want to prejudice any sentiments they may have. Look over. Of course, he's guilty. I mean,
he's
if
in
you saw
custody.
someone like that,
Yep.
You might think that. How delicate of a dance will it be for the defense here? I mean, clearly a trial, there's part of their strategy in creating the self-defense, storyline or defense was, those the victims here and those involved, they were scary, they were mean, they kind of created it. You heard the state sort of say, Nicolas Mui hasn't come to terms with humanizing those people involved. the defense, I know they still believe this was self-defense, but they're now just speaking to the judge, not a jury. So how do they delicately talk about kind of still blaming others for what happened that day, but arguing and arguing for a lesser sentence?
Yeah, they're definitely going to bring up the components that they feel supported self-defense. The fact that there were so many people, that the other tubers had escalated the incident. They were the one yelling, circling in on Mr. Mui. I anticipate that they're going to bring that up. And the reason is, again, the nature of the offense. It's something that the judge is to consider here. And so they're going to touch on it, but I wouldn't see them going so far as saying, it's the other tubers' fault. The other tubers could have walked away as well, and it was a split-second decision that was made by everyone in terms of how they were acting. So I would anticipate they're going to touch on it, but I don't think they're going to stay long.
You saw something just when the camera was obviously tightly, trained on Nicolas Mui. And this is interesting. We have a slightly different angle because during the trial itself, the camera was at a different point because the jurors, we didn't want to risk showing a juror accidentally, but clearly here we moved. My belief now is that the camera's actually in the jury box, facing Mui straight on. We don't typically get to see the defendant from the face. I mean, someone who covers these cases, I'm always behind the defendant, so it's providing us a unique perspective. And I know you're not a psychologist or anything, but you saw something in kind of Miu's demeanor, his head down. He didn't appear to be looking at notes, didn't appear to be, I don't want to say he wasn't processing it, but certainly his head bowed. But you saw something that maybe you wonder if he's going to speak today.
Yeah, I while they were panning on him, he appeared to not be looking at notes or not reading something. And it's very common, especially when the state is presenting their argument. It's very common that we tell our clients, obviously you should be listening to that, but when the state's making their argument, start looking at yours. Your time is coming very quickly. And so it didn't appear that he was looking at or reading anything. And so I had made a comment to you, Paul, that, is there a chance that he's not going to make a statement, or he's going to make an extremely short statement? That is a strategic decision. And now that we know about these jail calls, that becomes a more viable possibility at this point in time. That defense says, hey, let us argue this, because those jail calls, those are damning and those are powerful. And so it is possible he may not do it.
Is this the first time the judge would have heard about the jail calls, or would that, I don't know if they'd make it into PSI, would they? That would be state information. So yeah. I don't know if I haven't checked the case in the last hour. I don't know if the state submitted any arguments in advance, or could Judge Waterman be hearing about that type of behavior for the first time just now?
It would be unusual. Generally, the parties would have notified the judge about that. Again, here, there may have been some other legal arguments that were made regarding those calls, but again, they're not confidential. The individual in custody knows that they're being recorded. There are signs up over the phones. There's an audible response that when the defendant calls an individual, it says the call is being recorded and is subject to review. So it. And so certainly the state gets to use them and is able to make those arguments. But I would be surprised if this was the first time the judge was hearing about it. Also, the way that the state presented it, if it was the first time, I would have anticipated that they put transcripts on the board, something to really help it sink in with the judge.
And you did remind me there were arguments made during trial, very specific to some phone conversations with his now ex-wife, but his wife at the time, and what the judge was going to allow to be played. And it was a very small amount.
Oh.
Again, I think the judge recognizing some of the prejudicial value, had you presented some of that inflammatory, demeaning, kind of horrible, language to a jury. Our camera has come back up. You can see Judge Waterman's nameplate there. During trial, we would show you the state seal of Wisconsin, but perhaps we have a new photographer in court zeroing in on that, but certainly would seem like proceedings are imminent. We'll keep an eye on this as we go. Is there Debbie, a typical length of time you'd expect a defense? I mean, would they go a little bit longer than the state just because they may have a little bit more to say about it?
Yeah, generally, the state's argument wasn't extremely long here. I didn't time it, but my gut on it, maybe about 20 minutes or so. I would expect it to be a bit longer, and I see the judge now.
Yeah, Judge Waterman, let's take you out to St. Croix County Circuit Court, Hudson, Wisconsin.
Okay, we are back on the record. The attorneys are present along with Mr. Mui. Mr. Nelson, will you be delivering Mr. Mui's argument?
Yes, Judge, but I believe the state had something to add before I start.
I just noted my total was incorrect. All the specific lengths I gave for recommendations is correct. The total of initial confinement is 70 years.
Thank you. Mr. Nelson.
Thank you, Judge. I just want to start by obviously acknowledging that this was a tragedy all around. We completely understand and appreciate the heartbreaking loss and the grief that was suffered by the Schumann family, the other victims, and their entire family, their friends, everybody here in the courtroom for the most part. It's obvious that Isaac Schumann was a unique and special human being that was loved by innumerable people. As Your Honor knows, here today, defense has a unique role in this process. And so while as a human being, I definitely heard what was said, I'm going to focus on our role today, and I'm going to focus on the galleon factors. And the galleon factors, as we all know, we'll talk about it later, talk a lot about Mr. Mui, the seriousness of the crime, and the need to protect the public. So I just want the court to know, and obviously the public to know, that we heard the victims. We understand and appreciate that. I'm just going to move through and talk about the galleon factors. I think it's always important to, when I think of galleon, which I think it was cited in my sentencing memo, Your Honor, and I'm sure Your Honor's heard me say this before at other times. I've been in front of Your Honor numerous times, but my favorite quote in all of Wisconsin jurisprudence is from paragraph 36 of galleon. Experience has taught us to be cautious when reaching high consequence conclusions about human nature that seem to be intuitively correct at the moment. Better instead is a conclusion that is based on more complete and accurate information and reached by an organized framework for the exercise of discretion. I know Your Honor knows that quote. I know Your Honor will appropriately exercise your discretion. I didn't mean to imply that you wouldn't, but I think it's good for all of us. And I know obviously the court, Your Honor, is my audience today, but this isn't happening in a vacuum. And I think it's important for all of us as members of the court system to take that real responsibility on when we speak about things of this serious nature, which at the end of the day, this is as serious it gets in our profession, in the criminal justice system, the sentencing. How do we deal with loss within our society, within the court system, within this courtroom? It's a profound question that I think demands incredible attention, and that's what I'm going to try to give it today. That quote ends with the exercise of discretion, and in galleon, again, as Your Honor knows, the courts talk about discretion in a way that makes clear the use of discretion is using the process of reasoning and a logical rationale. And so if you indulge me for a moment, just to quote from paragraph 3, discretion is not synonymous with decision-making. Rather, the term contemplates a process of reasoning. Paragraph 6, in this opinion, we examine the process of reasoning. Paragraph 19, quoting McCleary, the term discretion implies a process of reasoning. This process must depend upon facts that are of record and that are reasonably derived by the inference from the record and a conclusion based on a logical rationale founded on proper legal standards. They go on to say in paragraph 22 more about a rationale. Paragraph 39, a rational and explainable basis. Paragraph 49, a rational and explainable basis. Paragraph 15, a rationale for sentencing. Decisions must be knowable. And I'm going to address that a little bit more when I do get to I think near the end, when I address punishment and retribution. Because I think this framework for us here in a court system using rationale to try, maybe unsuccessfully, but to try to figure out what we do as a society when loss has been suffered. And part of that rationale, Judge, is clearly morality, right? I don't want to go on too far about, what's the purpose of the criminal justice system, but I think in many, many, many ways, it is a system to try to impart and show our common morality and the morality that we believe in as a community. I think morality, and I think there's hundreds of years of philosophers who support that essentially morality is by its nature both forward-looking and functional. And I think that's a key theme at any sentencing is we're looking towards the future. Obvious, we're here about the past, right? There's been crimes that were committed that he was convicted of. There's loss that happened in the past. But morality in sentencing, I think at its core, is forward-looking and functional. The natural purpose of morality, even the retributive impulse, is to shape future behavior advantageously for our community, for our society. Any reasoned moral response to past behavior must consider the best means to achieve what our community's desired ends are and how most effective we can be on those future offenses. And I say that, and I'm maybe taking some things out of context, but one of the matters that Mr. Anderson addressed, right, in his comments, and I appreciate this, that he was critical of Mr. Mui's actions on the river. He essentially said, and you, Honor, just heard it, so I'm not quoting word for word, but what I heard him say, he was critical because according to Mr. Anderson in the state, Mr. Mui was acting on vengeance to get even. That's one of the things that the state had said. Now, I don't want to this isn't the time for factual disputes. I get that. So I'm going to put that aside whether I agree with their conclusion about what the facts lead to show. But what we know and we both agree upon is that's a recognition that vengeance is an emotion that we ought not promote. Vengeance is not something that we ought to model. Vengeance is not something that I think any of us should aspire to or aspire others towards. Justice is different than vengeance. And I don't think this court, any court, while the natural human feelings of those who've suffered loss may involve those very instinctual, common, emotional feelings that all label vengeance or some sort of strike back. That is not something we all agree we should promote. And my hope is at the end of this that Your Honor will have some words to address that and address the meaning of sentences and the purpose of that and how they may differ from vengeance. So back to Galleon. As Your Honor knows, Galleon cites the law, the starting point for the law on any sentence, even this sentence, and I'm quoting the law. Probation should be considered as the first alternative. That's what Galleon says. It then quotes Bastion, Bastion, paragraph 25, adopted the ABA standard 1.3 relating to probation. And again, as Your Honor knows, maybe Your Honor will address this in your comments, but this is the framework where we as lawyers in the court of law in a system designed by social contract that we've all agreed upon. This is the framework which we do. And it says probation should be the sentence unless the court finds that, one, confinement is necessary to protect the public from future criminal activity by Mr. Mui, or two, Mr. Mui is in need of correctional treatment, which can most effectively be provided if he is confined, or three, which I think is what the majority of what we'll be talking about today, I will be, is number three, or it would unduly depreciate the seriousness of the offense if a sentence of probation were imposed. So with that framework, Judge, I want to talk about those three different factors, or three different questions that need to be answered. Obviously, within that, Gallion also talks about the three sentencing factors, which I think are somewhat parallel, if not consistent with that, and that is the character of Mr. Mui, the need to protect the public, and the seriousness of the offense. So I'm using it in the framework of these three questions outlined by the standard 1.3 of the ABA standards. So first off, is confinement necessary to protect the public from Mr. Mui? That's where I think we think of his character, right? And I understand that the state and some of the other speakers today made comments about Mr. Mui's character, and I understand why they may have those opinions. But the facts, the cold hard facts, are that Mr. Mui, prior to this time when he was on the river, has never been in trouble. He was an upstanding, moral human being. He had, as you know, in the sentencing memorandum and in the PSI, but just to quickly outline, he was born in Romania. He and his family, for lack of a better term, were treated poorly there. A circumstance that was outside of his control, and they managed to leave that circumstance and come to America. But like some other things in Mr. Mui's life, that wasn't in his control. He didn't sign up to be born into a communist Romanian country. He didn't sign up to be persecuted in that communist regime. He came here and had what I think we would all consider the American dream. An immigrant, came here, he learned the language, he adopted America, he assimilated into our country, and he was a productive member of society, getting an education, being employed, and having positive relationships throughout his adulthood. The state has mentioned some things about his character that I feel like I don't want to belabor it too much, because I don't think at the end of the day, there's really much question about his character. The state's talked about his phone calls, right? What Your Honor probably knows is he's been in custody for 2 years and a day. About 732 days he's been in the St. Croix County Jail. During that time, he's had some phone calls. The state mentioned some of these phone calls. I will just say, without us being distracted by these phone calls, that we dispute the translation on many of those phone calls. In particular, the word bastard. That's not the Romanian word that Nikolai used. I think the proper translation would be an unfortunate. And so that's a very different context in which this was said. Second thing I think is Mr. Mui has been in custody for this time. Like, I think anybody, whether he was involved in this traumatic event, right? He's been suffering PTSD while he's in the jail. That's documented through the jail records, through the medical records. He's been going through his own process. These phone calls that are mentioned, you don't get a timeline. You don't get a date. Many of them, based upon my memory of those phone calls, which wasn't a huge part of the trial, was these happened in the first 30 to 60 days of his incarceration. These weren't from yesterday. These weren't from last month. These weren't from around the time of the trial. These were much, much further back in time. And I say that because remorse is something that the state talked about, and they talked about it in the context of Mr. Mui's character. I think Your Honor knows the criminal justice system in America is good at several things. It's not really good at allowing sometimes a space for a person in Mr. Mui's position to express remorse in a safe space. The only people that he'd be able to do that with are myself and Mr. Chirafisi. I don't want to make myself a witness, but I can tell Your Honor's office of the court, he has processed this. He has shown in the numerous times, the tens, if not hundreds of times that I've met with him, remorse over different times in the action. A lot of mixed emotions, probably not one emotion that he's been showing, but there has definitely been remorse. One story that he's given me permission to tell is very soon into this, after the event. The state approached me as his lawyer and asked about the release of Isaac's body. As we heard from his sister, Isaac's body was evidence. That must be a devastating thing that they had to deal with. And Mr. Anderson reached out to me to see if the defense would release the body. And of course, I did my duty. The first thing I did is I went and I spoke with my client, Mr. Mui. And when I made that question, I approached Mr. Mui with that question, he looked at me aghast. He could not believe that that had not already happened. And he broke down emotionally and wept. He just wept. Maybe there was other things that came in. Maybe this was a time when I first met him, when we were starting to get to know him. Maybe it's a time that this loss that had happened became more real for him. But in that moment, he showed what I think was remorse. They weren't there to see it. And they weren't there to hear about it until today. And if we could redesign this criminal justice system in a way that maybe we could give some of those things to the victims' families beforehand as we're going through this, I think there might be other healing. There might be other things that can go through. I understand and appreciate why they might feel the way that they do. But I can tell you, I've been with him. I've been with him over those 732 days, and he has shown remorse. Is it mixed? Is it complicated? Absolutely. Are there times that he has some other feelings that are all mixed in with this? Yes. But I submit to you that he has shown remorse, and it has become more and more and more so as we have moved through the process. His character, Judge, at the end of the day, we're here to judge him on his actions, right? He's here because of an action. And I think that all of us as human beings, at the end of the day, we have thoughts, we have opinions, we might make comments, and sometimes our words might be considered actions. But at the end of the day, when you add it all up, you're going to judge me, all of us, the world judges us on our actions. And this day, July 30th, that 2 minutes, right? We'll expand the time limit. That's the first time that his actions, I think, become into question. And what in any other context, I'm not trying to belittle what we're doing here. It's serious. If I make an analogy that's poor, I apologize. But in any other context, if we were seeing somebody's performance across a field, whether that be in a sport, whether that be in academics, whether that be in a profession, if they've demonstrated through factual data points, and we measured all of their actions, and they had one data point, horrible, glaring, big red data point that's at the bottom of the scale, right? If all of our points are measured across a scale, birth to death, and we hopefully develop and grow as we go across time, and our actions improve on our development of moral development in society. If somebody has one data point that's below that line, common sense tells us in every other capacity, in every other field, you don't overcorrect based upon one data point. And that's why I think his character I get that that's just one part of this. I don't want to say it's equation, one part of this analysis, but that's what common sense tells us and everything else. If you objectively measure it with the PSI did, he is low risk statistically. He didn't ask to take the PSI. He didn't ask to get measured on Compass, but it happened. And one of the things that the Compass came back and told us is he's low risk, which makes sense for somebody who's 54 now. At the time he was 52 and had never been in trouble before. That's low risk. That's what the objective evidence, if you were going to use a process of reasoning or rationale, that's what that shows. I do think, and I don't want to, I appreciate that there's been a guilty verdict. I'm not trying to relitigate matters about what happened on the river. But I think when you think of his character, and later when you think about need to protect the public, or when you think about punishment, all of those aspects, we have to consider the circumstances of the event. That's just the plain reality of this. And the circumstances, the factors, the conditions, the circumstances played an essential role in shaping Mr. Mui's reactions. He didn't put himself in that position. I've definitely heard talk, and I will address it later, about could he have gotten himself out of that position in other ways. I understand that, and I'll address that. But we have to know that he didn't put himself in that position. The state, I think even again, in their acknowledgement, right, one of the things that they were critical of him is they said he should have de-escalated by showing the knife. And I'll get to that. But I think that's also just a common sense acknowledgement that somebody else, other people, the circumstances were being escalated by people other than Mr. Mui. He was in that position. There may have been other things that he could have done to do that, but it's not of his necessarily control, excuse me. So I just, again, we're here to talk about Mr. Mui, and we're here to talk about Mr. Mui's actions or reactions, and you're here to judge those, and you're not here to judge or blame others. I get that, and I appreciate that. But his actions, his reactions did not occur in a vacuum. It did not occur in a vacuum. The second question, moving on from his character to some degree, is, and again, just I sent Your Honor a letter. There was numerous quotes from all of his family and friend. He's got numerous family and friend that are here. And some of them even asked me, could I approach, could we say something on behalf of Nick? And I appreciate why somebody would want to do that. My hope is that Your Honor, through the PSI, through the letters that that I submitted, through the letters that other people wrote and that I submitted, Your Honor gets a picture of who Mr. Mui is. And it's, while calling witnesses might help this process today, I don't think it's going to help Your Honor. And at the end of the day, I think my audience is the court. So what's the next question? The next question is Mr. Mui in need of correctional treatment which can most effectively be provided in confinement? And I think the answer to that clearly is no. There is nothing in the PSI. There's nothing in his character. There is nothing in any of the information that's been submitted to the court that he has any treatment needs. There's been this potential about alcohol. I understand that, right? And one of the things that Mr. Mui wanted me to point out regarding the correction from the PSI regarding substance abuse history, in particular pages 22 through 34. It's probably just easier for me to quote his words. It's not as much a correction as just maybe some things were left out. And his words to me were, I rarely drank any alcohol in college, and when I did, it was beer only, never hard liquor. Rarely drank more than 1 to 2 beers, and rarely until I would get a buzz. I avoided getting a buzz. I did not like beer or any type of alcohol in the beginning at 23 years old. I drank socially only. So that's, again, it's not, I don't think, nobody said that he was intoxicated on that river. The PSI acknowledges that that's not what the evidence was. Was there alcohol involved? Yes. The witnesses that testified, the witnesses that submitted to him, he's not in need of treatment for any substance abuse. There's no other need that he could only get in prison, right? And even if there was, whatever, again, I don't think that there's an alcohol problem, but I think it's undisputed that treatment for alcohol can best be provided in the community. So he doesn't have needs. He's educated, he's employed, he has no record, no past behavior. The treatment, right? I think at some point, if we're talking about sentencing is about modifying our attempts, the court system, the court attempts at modifying another human being's behavior, right? Either through moral education or giving them other tools, other skills so that they are reduced risk. In this situation, if you're talking about the morality, we have to again consider the circumstances of this event. We have to, right? I understand Mr. Anderson does not agree with my analysis of the verdict. There's probably never going to be an answer as to whether or not, to what degree self-defense was considered by the jury, or whether there's been any factual finding that he, in fact, had an actual belief that he was acting in fear. I think the evidence supported that. My conclusion, as I put in the writing, was that the jury determined that his beliefs were unreasonable, and that's why self-defense didn't apply. Your Honor is going to be able to do that in your own context. So I'm not trying to relitigate, but I think that that's important here, because it's our position that he had a sincerely held belief. Mistaken, wrong, unreasonable, but the jury found it to be reckless. This is not an intentional act that needs to be modified. The state, even though they didn't say that, their implication is what he did was something that's intentional. They talk about his smirking. They talk about his doing other things as if this is something that he intended. The jury denied that. They denied that theory. They rejected that theory.
So why did he do it?
This is a reckless act. And I think when we're talking about how do we modify someone's behavior, you're different than if you're modifying a reckless act than if you're modifying an intentional act. This wasn't criminal thinking, right? This was somebody who was in a situation, and again, I appreciate this people might be, but overreacted, right? That there was a tool, he used that tool, and he used it to a degree that the jury found to be reckless. But I think that that becomes something that we need to consider, right? There's no treatment modification because he didn't act with malice and forethought. He didn't act with malice and forethought, right? He reacted out of fear. And while that may be criminal, that's something I think that he needs any treatment for. So again, that's all in response to that second question, right? Which really leads us to, I think, the core of this matter. Would probation unduly depreciate the seriousness of the offense? I think the answer is yes.
Oh, Lordy,
I think
Lordy.
the answer is yes. I imagine Your Honor's not surprised that I would say that.
You need to sit down.
But I think we need to think about how that should be issued, right?
Sit down, buddy.
And I say that there are, what I'm afraid of in this case and in all cases, and in general, when we talk about sentencing and we have to make sure it's not unduly depreciated, is that we have an entire system, right? An entire system of justice that appreciates the seriousness of crime.
Not a hope. Dingo,
And
not a
for,
hope.
I think, anyone, a PSI writer, an attorney representing the state, the public, the media, for anyone to try to simplify it, to say that the only way in which we can appreciate the seriousness of something is a number in prison, a length of prison sentence. I think that that is disrespectful to the entire criminal justice system. I think that that undermines all the other things that we do in the criminal justice system, because we appreciate, in this part of this whole process is an appreciation of that. And I hope that the public, everybody understands that. There's an arrest. There's incarceration for 732 days, which, as Your Honor knows, that doesn't happen in most cases. Most people are let go on bond. And I'm not critical of the decision to not, but that is obviously an appreciation of the seriousness of the offense. There are numerous court hearings. There is jury selection. We went through the jury selection process in this case through all of those questionnaires, all of those other things to make sure that we get it right. And I appreciate the level of detail that we did, but that is, again, a way in which we appreciate the seriousness of this case, because we don't do that in all of the cases. I know that. We don't. And we should have done it in this case, and we did do it in this case, and we did it because of the seriousness of the case. There's clearly a trial. There's now been a conviction, right? He's now a felon, and he's going to be sent to Wisconsin State Prison System.
Yeah.
Right? Those are all recognitions of the seriousness of the offense. My complaint might be the wrong word. My criticism, I think, is of sometimes how we do sentencing is that we push all of that aside and try to say, we have to do a number, right? It's like a contest. Whoever can produce this bigger number, that's where we go to. That's not what I think we should be doing in the criminal justice system. It should be measured. It should be thoughtful, right? It should be wise. I don't think, it's not an equation, right? It's not just simply math. And while numbers are important, we don't value lives with a number. We don't value character of people by a number. There is no way that we can put into numbers the loss that the Schumann family has articulated. And I get that. I also get the desire to try to do that. But that's not something we can accomplish. We just can't. I wish we could. I really do. As one human being to another, I wish we could. But how, again, I'm not trying to imply how we in this system, we use our words. Right? We use our words to explain things as galleon things. And I think it's to explain things in a moral sense. It's too simplistic if we rely upon a number. And it undermines the evaluation and the appreciation of all the other aspects of the criminal justice system if we do that. Again, duly depreciate. Appreciation, I think, is about the future and deterrence, right? There's no science, zero research that any sentence that is given in a case is going to deter others. It's one of the most studied things within the criminal justice system. And general deterrence, there's no evidence that that works. So while I appreciate the desire for that we want to do that, we want to do something here that is going to change the future for the rest of the world. I get that. That's a wonderful desire to have. But the science says that's naive, that's not what's going to happen, because that doesn't happen. And I think it's even more so in a case where we're talking about things of a reckless nature rather than an intentional nature. And here's where I think I need to go back and address some of the thoughts that people have about
guy
Mr.
had a
Mui.
machete in his
And I
vehicle.
understand why they would have those thoughts, and whether it's the state calling him a monster or evil, or whether those other people, right? I don't think that helps anything. And here's why. if we're really trying to craft a sentence that is going to have some influence on people watching, people who read this, people into the public, right? If the court system says he's, and I don't think the court would, I've never heard the court use name, if considers him some sort of monster or evil, it's easy. It's easy for everybody on the camera, everybody who writes this, everybody who reads about it, to other Mr. Mui, to think of him as somebody so different than themselves that this case, this sentence, these actions don't apply to me as a human being. And that's the danger. That actually undermines what Your Honor is trying to do if Your Honor is thinking about the future and whatever happens here has some sort of influence on the public. Mr. Mui is a good man.
Okay, then.
He was in this situation and he's been convicted of doing a crime.
Yep.
And that doesn't diminish the consequences of his actions. But to talk about it in a way in which we other the person who does that, I think doesn't recognize the reality of all of our vulnerabilities out in this world. All of us in different situations, and all of our also responsibilities to do what we can in different situations to either prevent and or de-escalate violence. This was not something done by a monster. This was something done because of some circumstances that lots of people played a role in. Mr. Mui, at the end of the day, is here to be accountable for his role in that. And circling somewhat back to just the accountability, right, Judge, and seriousness of the case, as well as remorse. There's, as Your Honor may be familiar with, there's a author in America by the name of Michelle Alexander. She wrote a book about the criminal justice system back in 2010. She's also occasionally writes in the New York Times an opinion, right? And I just want to quote some of an article that she wrote back in 2009. Survivors are right to question incarceration as a strategy for violence reduction. Violence is driven by shame, exposure to violence, isolation, and an inability to meet one's economic needs, all of which are core features of imprisonment. Perhaps most importantly, according to Ms. Sade, that's a different author that she's quoting, that wrote a book called Until We Reckon. According to Ms. Sade, quote, nearly everyone who has committed violence first survived it. And studies indicate that experienced violence is the greater predictor of committing it. Caging and isolating a person who's already been damaged by violence is hardly a recipe for positive transformation. She goes on to say, in many ways, when she talks about accountability, and this is where I want to circle back to remorse and Mr. Mui's being, through the system, isolated and not able to have contact necessarily with what we call restorative justice programs while the case is going on. Quote, our criminal injustice system lets people off the hook, as they are not obligated to answer the victim's questions, listen to them, honor their pain, express genuine remorse, or do what they can to repair the harm that they've done. They're not required to take those steps to heal themselves or address their own trauma, so they're less likely to harm others in the future. The only thing prison requires is that people stay in their cages and somehow endure the isolation and violence of captivity. Prison deprives everyone concerned, victims and those who have caused harm, as well as impacted families and community, deprives them of the opportunity to heal, honor their own humanity, and break cycles of violence that have destroyed far too many lives. I quote from that, Judge, because while I recognize this is a prison case, the amount of prison is clearly in debate. It's clearly something that Your Honor is going to decide. And how do we break these cycles? And somewhat is a cycle of mindset of somebody gets harmed and they react and respond to that harm. And we're here to judge Mr. Mui for that reaction that he had in this setting that he did not set up. So what do we do as trained professionals who've had 732 days to contemplate what's the right response in a safe setting? I can't imagine a more difficult task. And I know I've heard Your Honor, if not other judges, say that sentencing is the most difficult task. But it's that measured response that I think we are required to give. In talking about the circumstances of the case, Judge, I do want to address just 4 points about the circumstance of the case, right? One of the things, is that's been talked about in the PSI, as well as in statements today, as well as in arguments today, is, walk away. I understand that, and I appreciate that. And I'm not trying to excuse, I'm trying to offer something that Gallion talks about is an ability to explain and articulate to Your Honor, so Your Honor might have a better understanding. And so I think the public can have a better understanding about what it is that created this situation. We know through the video that there was Mr. Mui was walking away when some of the group of football players called him raper. And we know he responded to that. And I appreciate that the state's position is he should not have responded. He should have kept walking away. And I'm not trying to explicitly say disagree with that, but I'm trying to get so Your Honor might understand why a human being might respond to that. I think that those name calling, whether it's raper, whether it's pedophile, those are different than calling somebody a name that's specific to that person, right? That's just about not what they've done, but about their moral character. We've all heard the names, whether they start with an A or a B or a D or whatever it is. We've heard those names that I think lots of human beings have heard and they've walked away. When you're called something that says you have violated society's norms that I think we would all agree, everybody in this courtroom, that it's just, it's horrific, right? To be a raper, to be a pedophile who is preying upon somebody who's vulnerable, to be called that and to walk away might be seen as tacit agreement, right? Tacit agreement into those behaviors. And so I'm not saying everybody would, I'm not saying anybody should, but I can understand why somebody who's pro-social, who believes in community norms, might say, look, you can't call me that. You can't call other people that. You're breaking some norms about what you're saying, and I have to stand up to that to say, that's not okay. Not just the name calling, but that behavior that you accuse me of. It's not about the person, it's about those social norms. And that's something that I think you can't walk away with because you can't really say who cares. Somebody addresses you in that way, I think to walk away is to say who cares. And you know what? I do care. I would hope lots of people care. Lots of people would care if young, vulnerable people, children are sexually assaulted, women are raped. We should care. And a response to that kind of comment, I think, is at its core an expression of caring about that. That's why he turned around. It's not bad character. It wasn't an intent to harm. Then we come to the point where they talk about he should have walked away. And I get it. The 1 minute and 42 seconds into the video, he's standing, he's got the knife in his hand, there's 2 women in front of him, and there's other people that we can't see. I understand eventually we need to get to that 1 minute and 42 seconds into the video. But prior to that, the uncontested facts are he walks away twice. He did walk away. He walked away down the river to away from the group of football players that were tubing. And then he walked across the river to go over and talk to the other group of adults. He did walk away twice. Appreciate that the state's position is he should have walked away a third time. I understand that. But to say he didn't walk away, I think is inaccurate. And I think the record needs to show Mr. Mui always deserves to be sentenced upon an accurate record. He, in that situation, when he walked to the second time, as we've all seen in the video, he used his words. And it was shut down. And from then on, everybody has said he didn't use his words. That's what the state said. That's what some of the people who spoke today is he didn't use his words. I understand and appreciate that. As somebody who makes their living using my words, I appreciate the value in words. As somebody who listens to courts use words to solve problems, I appreciate the value in words. That's what he could be judged on, because he didn't use words. Why didn't he? We don't know. I think he said he was overwhelmed. He was afraid. He didn't know what to say. Could it be part of the language barrier? Could it have been other things? I don't know. But I think we need to put a pin in that. Use your words. What did he do then? Does the state say at the 1 minute and 42 second, he had a tool with him? We know he had a tool. It was a knife. And he opened up that tool and had it in his hand at 1:42. As the state said, he should have de-escalated it by showing the knife. I think that's worth mentioning because I think it's a tacit agreement, at least from a moral standpoint, if not just a legal standpoint and a factual standpoint, a moral standpoint, that circumstance was perhaps worthy of a person showing a weapon. He didn't, but I think that's to understand the circumstances. I think that's essentially even if we disagree with it, we might understand why somebody in that position would take out their tool, right? He had a tool, and at the end of the day, he had a tool that nobody else had. He had a tool that nobody else had, and the manner in which he used that tool is why he's here. And I think the state's position is he used that tool harshly, right? But, and I think this is the last point on the circumstances of this, but it's an undisputed fact.
Holy smokes, buddy.
Deserves to
Holy
be sentenced
smokes.
on accurate facts. He did not use that tool until violence had been done to him. Should he have used the tool? The jury said no, right? But I think in judging his actions and judging his character, that is something that I think is you have to consider. He did not use that until it was used upon him. The appreciation obviously goes towards the PSI as well, right? The appreciation of the wrongfulness. And I say that because, as Your Honor knows, I'm not telling you anything, that there's an executive branch. The executive branch is represented by the district attorney's office, represented today by Mr. Anderson and Mr. Smeestad. Mr. Anderson spoke. That's the executive branch. As often happens in a judicial setting, the judge, as you did here, asks other parties of the executive branch to make a report. In this case, it was the Department of Corrections. They made out a report. One of my position, what I submit to Your Honor is there's a reason we put judges in charge of this and not the executive branch. Do not, I would submit to you, I would encourage you, try to persuade you, don't abdicate your authority to the executive branch. Don't abdicate your authority to a non-lawyer who doesn't have the same duties that a judge does. We all know judges have different duties. Gallion spells them out. There's all kinds of other things that I know I couldn't even list about the duties that a judge has that are different than a DOC agent, right? They're not bound by the law. They're not bound by Gallion. They're not bound by a process of reasoning. They're not bound by a logical rationale. And I say that because I'm going to submit here as an exhibit
Yes, we'll have it marked as exhibit number 1 in a moment.
Probably 2. I think the state had exhibit number 1.
2?
Thank you.
To the two.
Your Honor probably knows, I hope, if not, for everybody to know, is the Department of Corrections has what we call a grid, right? They have sentencing recommendations for what should be recommended in the PSI for different cases. And it's a 9-box grid. You know, on the left is whether somebody's low risk, medium risk, or high risk. And across the top is whether the matter is mitigated, neutral, or aggravated. You know, I'm going to use the term guidelines. They're not legal guidelines, all right? But it's certainly something that the DOC has. There's no mention of this anywhere within the PSI. Zero mention of this anywhere within the PSI. Nor is there any number on this grid that is consistent with the numbers that were submitted by the PSI. For lack of a better term, they went off the grid. Absolutely went off the grid. In the recommendations to the Department of Corrections as to how to use that grid, right? There's different things about assessing the severity of offenses and whether or not something can be mitigated, neutral, or aggravated. And all of the guidelines talk about how if they're going to claim something is aggravated, they need to list the reasons why. Not quite as strong as Gallion to talk about a process of reasoning, or a rational, logical basis, but it does talk about that. And the Department of Corrections in no way justifies how they got to aggravated, if they did. I submit to you that this is mitigated. It's mitigated because it's reckless. It's mitigated because of the circumstances surrounding this that were not all of Mr. Mui's doing. And if you look at that box, if you look at the box where it says it's mitigated and it's lower risk, as Your Honor said, that's a blue box. And the blue box says no presumption of prison or probation. It's based on the circumstances. The number inside that box says 1 to 2 years. Very different numbers than what the PSI recommended, very different numbers than what the state recommended. But that's a process of reasoning. That's a rational, logical way to get to something. They, by they, I mean the Department of Corrections, didn't follow their own rules and didn't explain it. The interesting thing for me in Gallion, when it talks about it needs to be an explainable sentence, it needs to be an explainable sentence. You need to be able to articulate it. And I don't know if this is my common experience with that, judges. I've been at times, despite perhaps my verbosity today and in other times, I can't always explain things. There's been times when I've had a conversation with my wife, who's, as you know, smarter than me, wiser than me, more thoughtful than me in so many ways. And we're talking about something and she'll be like, well, articulate the reasons why. Explain it.
Why are we now hearing
She'll
about
even
his
set me up
wife?
sometimes where she'll give me time.
Come on, sit down.
And I can't. I can't. Whether it's dealing with our children, whether it's something else in the household, and she'll come back and be like, yeah, you can't because that's an intuition, because that's an emotion, and appreciate all of that. But at the end of the day, that's not how we, I think as human beings, if we're mature and developed, should be making decisions. And it's clearly not what Gallion says we should be doing. We need to be able to articulate it and explain it. And if you can't articulate it, if you can't explain it, that essentially means it's because it's not rational, it's not following a process of reasoning. And I say that because all too often, and I can't recall, I don't mean to project onto Your Honor if I've heard it from Your Honor, but all too often I've heard that there needs to be punishment. And I appreciate that. I appreciate the value of punishment, but punishment is not an objective in and of itself. Punishment on its own is not worthy. We don't want anyone in the world to punish other people without some sort of future objective. Punishment is a tool. It's a tool that we use to shape the future. But punishment can't justify itself. And so when I've been in court, no disrespect to Your Honor, I don't think I've heard it from Your Honor, but when I've been in court and I've heard judges say, well, there just needs to be punishment. That is contrary to Gallion. That is something that they can't explain. That is something that they can't articulate. Punishment in and of itself is not an end. Punishment is a means. We know prison is punishment, right? We absolutely know that prison is punishment. That punishment, like I said, is not an objective. Punishment, if it's given, has to have a purpose. And because of the circumstances in this case, whatever that purpose is, I think it cannot, should not be vengeance. As I wrap up here, Judge, some of the things I want to tell you just are, we don't have the death penalty in the state of Wisconsin. But there are death penalty cases across the United States of America, in America. And in those death penalty cases in general, we ask the jury to do a duty, right? And what the jury is used, the jury's duty in that sense is to give, quote, a reasoned moral response to the evidence about the offense and the offender. A reasoned moral response. A reasoned moral response is not vengeance. Apologize.
Oh my word. Lordy, lordy.
So circling back to I would encourage Your Honor, don't abdicate your authority to the executive branch. The executive branch and the judicial branch are very different. In many ways, maybe this is an oversimplification, but when I think of the executive branch, I think they speak about, that's who we are. This is my community. I live in St. Croix County. I've lived here for 28 years. And this is my government. And Mr. Anderson speaks for my government. He speaks for who we are in this moment. I get that. I might disagree with him, but it's different for the judge. I think judges in the judicial branch, right? Judges speak about who we ought to be. Not who we are, but to speak to everybody here about who we ought to be. Right?
Oh my
There's a
word.
quote, if you will indulge me, that I have hanging in my office, painted on a wall. It's something that my wife gave to me.
Oh, here we go.
We have it in our home. Right? It's a quote from a German philosopher from, I think, the 17th century.
He's pretty bad,
Goethe.
Crispy.
I have come to the frightening conclusion that I am the decisive element. It is my personal approach that creates the climate. It is my daily mood that makes the weather. I possess tremendous power to make life miserable or joyous.
Oh,
I can be
God.
a tool of torture or an instrument of inspiration. I can humiliate or humor, hurt or heal. In all situations, it is my response that decides whether a crisis is escalated or de-escalated, and a person is humanized or dehumanized. If we treat people as they are, we make them worse. If we treat people as they ought to be, we help them to become what they are capable of becoming. Now that's incredibly profound quote, and I hope all of us at some point attempt to do that. We can't follow through all the time. That's an incredibly difficult task, especially here today, I have no doubt, Judge. But when we think of the judicial branch, we, not just Your Honor, the position, right? This is me as somebody who's been a participant, who went to law, who thinks of the law, the duty of the law. Judges, the judicial branch, we don't just want people who are smart. We want people with wisdom. We don't just want people who are thoughtful. I think we think of the judicial branch as someplace where there is measured. Not just analytical, but an understanding, right? And I've seen Your Honor. Your Honor has shown wisdom, shown measured responses, shown understanding of other human beings.
Oh, come on.
And I appreciate that today it's a incredibly
I'm
difficult
surprised
task.
the
that Your
judge
Honor
isn't
has.
shutting him down.
But let me end with this.
Oh.
Your Honor is the only one here with a tool that nobody else has. Your Honor has the power to send another human being to be in a cage, to be in prison. We ask that whatever Your Honor decides today, that you are measured, you use your wisdom, that you are understanding, and that you perhaps craft a sentence that gives the community what they want, but also here under Galleon allows Mr. Mui the opportunity to get back out and live some period of his life, some time in which he can perhaps do some of the things of accountability that we talk about that I think are going to be more meaningful than a number. So in the end, Judge, I appreciate that you have the tool of prison. Please
Oh my God.
use your words, not the tool.
Mr. Mui, this is your opportunity to make a statement, or if you wish, to offer any reason why I should not impose a sentence today. Would you like to make a statement?
Judge, he's written out a statement to me. I had it in hand. I printed it just for easier. I think he wants to read it, and then I'll submit it to the court, so it's just a part of the record.
Certainly. Mr. Mui.
Do you want to stand?
He has lost so much weight.
Dear parents, family, and friends of Isaac, I would like to start by letting you know how deeply sorrowed I have been. I am, and I will always be, for the real fact that Isaac is not with you anymore, and that I was directly involved in his very tragic and unimaginable death at such an early age. I never meant for this tragedy to occur. My soul is broken. My heart is very heavy. And I will never be the same carrying such a heavy burden and sorrow. I pray to God for forgiveness, compassion, and love for everyone affected directly and indirectly by the outcome of this tragic event. I'm hoping that you appreciate how much I'm sorry for the outcome of those events. I'm very sorry.
So we'll have that marked as Exhibit 3, Judge.
That'll be received into the record.
That's all then from the defense, Judge.
Mr. Mui appears today in court for sentencing. Count 1 is first-degree reckless homicide, which is a Class B felony. With the dangerous weapon enhancer, the maximum possible penalty is 45 years of incarceration, initial confinement, and 20 years of extended supervision. On counts 2 through 5, Mr. Mui appears for sentencing on first-degree reckless endangerment, Class F felonies with the dangerous weapon enhancer. The maximum possible penalties are 12.5 years initial confinement and 5 years of extended supervision. Last, count 6 is battery. That is a misdemeanor. With the dangerous weapon enhancer, he faces a maximum possible sentence of 15 months. In preparation for today's sentencing, I reviewed a number of materials. First, I reviewed the pre-sentence investigation report prepared by the Department of Corrections. It's a 43-page report that provided me with information that I knew and information that I did not know about Mr. Mui, about his victims, families, about Mr. Mui's background, about all aspects of this case, many of which were talked about today. That PSI report also included a sentencing recommendation. I also reviewed Mr. Nelson's sentencing memorandum. It was very helpful. It provided more information about Mr. Mui and his background, and I valued that information. Mr. Nelson submitted numerous letters from Mr. Mui's personal friends and coworkers. I read all of those. I also read the relevant portions of the file, including the complaint, the jury instructions, and the verdict. In a moment, I will pronounce a sentence that I believe is just and fair. When deciding on a sentence, I must consider the gravity of the offense, including the effect on the victims. I must consider Mr. Mui's character and his rehabilitative needs. I must consider the need to protect the public. The sentence must be based on the facts of the case and the law, not personal considerations, passions, or prejudices. But judges in Wisconsin have a great deal of discretion when imposing a sentence. Unlike many jurisdictions, we do not have sentencing guidelines or grids to follow. I want all of you to know that I have given this case a great deal of thought. I take my responsibility seriously. There is nothing more difficult or more solemn than imposing a sentence on another human being. As far as the gravity of the offense, the jury has spoken. Any efforts to relitigate this case are simply without merit. I firmly believe that the American criminal justice system is the best ever devised. It's not perfect, but I cannot think of a system of justice that is better at finding the truth while preserving the rights of the accused. In this case, 12 jurors reached a unanimous verdict. These 12 jurors were selected from a panel of more than 150 people. I, along with the attorneys for both sides, chose these jurors because they could be fair and impartial. The jurors came from all corners of our great county. They came from all walks of life. They were men, they were women, they were young, they were old. They listened to 8 days of intense trial testimony. They examined dozens of exhibits. They deliberated for 8 hours. In the end, they reached a unanimous verdict and found beyond a reasonable doubt that Mr. Mui was guilty of reckless homicide, reckless endangerment, and battery. Now, there are 2 key takeaways from this jury's verdict that I want to mention. First, the jury rejected the state's claim that Mr. Mui intended to kill Isaac Schumann or the surviving stabbing victims. In other words, the jury rejected the most serious crimes that would have sent Mr. Mui to prison for the rest of his life. Second, the jury rejected Mr. Mui's claims of self-defense. That means Mr. Mui did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or he did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself. This jury found Mr. Mui guilty of reckless homicide and 4 counts of reckless endangerment. These crimes are serious. They mean that Mr. Mui did not think about the consequences of his behavior, and that he showed utter disregard for life when he stabbed 5 people. For that, he will be held accountable, but the court sentence must reflect the reality that it was reckless conduct that the jury found him guilty of, not intentional conduct, which is punishable much more harshly. In weighing the gravity of the offense, I consider the impact these crimes have had on the victims. The battery to Madison Cohen was unjustified. While she did not suffer any permanent physical injuries, she has mentally suffered over this entire ordeal. She described to the PSI author the toll this case has taken and continues to take on her. This offense has devastated Isaac Schuman's parents and stepfather. No parent should have to endure the loss of a child.
No.
They have had to cope with the senseless death of a loved one while enduring the weight of the criminal justice system that can be slow, confusing, and sometimes frustrating to victims. To you and to your family, there are probably no words that I can say today that will alleviate your grief. But I would be remiss for not expressing my sincere condolences to all of you. I am sorry for your loss and what you've had to endure. Although it must have been difficult, I appreciate each of you speaking today and sharing a glimpse into Isaac's life and who he was. It sounds like he was a wonderful person, bright young man who had an unlimited future. And for that, we in this community have lost. A.J. Martin and Riley Madison would have died on that riverbank had it not been for the swift action of law enforcement and EMTs and other tubers who helped to treat their wounds and stabilize their condition. They had long hospital stays, but they were very fortunate to receive high-quality medical treatment that restored their health. But we heard from them about the toll this matter has taken on their health, their mental psyche, and their prospects for the future. Anthony Carlson and Dante Carlson's wounds were less severe, but the risk to life was still present, obviously because the knife was directed into their torso near vital organs. But they fortunately have survived. Each of these surviving stabbing victims suffered permanent physical disfigurement. That can't be overlooked. And we've heard from A.J. Martin just about how that disfigurement can affect one's life. In assessing Mr. Mui's character, I must consider his conduct on July 30. Mr. Mui's crimes were the product of circumstance, not intent. Mr. Mui was not looking to cause trouble or hurt anyone, but he made a series of very poor decisions. When confronted with words and boorish taunts and insults, Mr. Mui drew a knife and he struck Madison Cohen. That quickly culminated in senseless, lethal violence. He left the scene, leaving his victims to die, while casually floating past them and emergency workers as if nothing had happened. He nearly reached his car. He nearly escaped the jurisdiction before law enforcement arrested him. These are terrible acts that form an indelible stain on his character.
All truth.
There is more to Mr. Mui than his worst acts. I can tell Mr. Mui has taken this case very seriously. He has been appropriate and respectful in his demeanor in court. I sense that he carries a heavy burden too. I imagine he is disheartened at the prospect of prison and the uncertainty of his future. But I also sense that Mr. Mui feels genuine sadness and remorse for what happened to his victims. I agree with the comments earlier that our criminal justice system is not designed in a way to allow people to apologize or to alleviate grief or to show respect to victims until a day like today at sentencing. That is unfortunate, but I heard Mr. Mui's words, both today and before, and I think he is sorry. Other than his conduct on July 30, Mr. Mui appears to be a quiet, nonviolent, peaceful man. He's never been in trouble before. He is loved by his family and friends. He's generous with his time. He helps others who are less fortunate or who are in need. Mr. Mui is respected in his community. Several of his personal friends and coworkers submitted letters that describe his character. Those letters were not shared in court today, but some of the most common words they use to describe Mr. Mui are kind, compassionate, friendly, loyal, respectful, and honest. Mr. Mui had to overcome great obstacles in life to achieve his place. He and his family suffered at the brutal hands of the communist regime in Romania. When he was a teenager, he and his family fled. They found asylum in the United States. Here, he adjusted to a new country, new language, new culture. He got good grades in high school. He went on to college in South Dakota. He became an engineer. He worked hard. He had a successful career. I read somewhere in my materials that the proudest moment in Mr. Mui's life was becoming an American citizen. Mr. Mui has no rehabilitative needs. That means he doesn't need rehabilitation. He has no past criminal history. He does not associate with criminals. He has never used illegal drugs. He is not an alcoholic. He has not been diagnosed with a mental health condition, although there is evidence that he's experienced PTSD from July 30 while in the jail. Mr. Mui was educated. He has vocational skills. He has life skills. He's financially secure. He has a stable home. He has positive social supports. He knows the difference between right and wrong. He doesn't need rehabilitation. I mention all of these things to acknowledge that there is a lot more to Mr. Mui than what he did on July 30. I mention these things to recognize that a fair and just sentence takes into account the complete person, not just his worst acts at his lowest moment. Despite the seriousness of Mr. Mui's crimes, the evidence does not show that he poses an imminent risk to the public. Mr. Mui underwent a COMPASS assessment, which is an actuarial tool that measures a person's risk of committing future crimes. Not surprisingly, Mr. Mui scored low risk. He's not a career criminal. He's not a violent predator. Although Mr. Mui may not pose an imminent risk to the public does have a strong interest in holding people accountable who breach the social compact and commit crimes. It's the concept of punishment. Punishment is a sentencing objective. When a person commits a serious crime, that person forfeits rights enjoyed by the law-abiding community. The most restrictive punishments are reserved for those who commit the most serious crimes. The punishment exacts a toll on the offender because of the harm the offender caused to the victim and the community. Taking life and endangering the lives of others are two crimes that warrant significant punishment. Punishment for what Mr. Mui did, but also punishment that recognizes who he is and the circumstances of his crimes. Here, that punishment will involve the loss of liberty, because anything else would depreciate the seriousness of his crimes. So at this time, I will impose the following sentence on Mr. Mui.
Here we go, guys.
For count one, I will impose a term of initial confinement of 20 years, followed by 6 years of extended supervision. For count two, involving Anthony Carlson, 5 years initial confinement, followed by 5 years of extended supervision. Count three, involving Dante Carlson, 5 years of initial confinement, followed by 5 years of extended supervision. Count four, Alexander Martin, 6 years of initial confinement, followed by 5 years of extended supervision. Count five, Riley Madison, 5 years initial confinement, followed by 5 years of extended supervision. Count six, Madison Cohen, 270 days of jail. Mr. Mui was not eligible for challenge incarceration program or the earned release program due to his age and the nature of these offenses.
That's what I'm wondering.
The sentences on all 6 counts will run concurrent. I am imposing a concurrent sentence because Mr. Mui's conduct toward each of his victims was part of a single continuous act over a short period of time. Periods of confinement take into consideration Mr. Mui's entire behavior, not just the behavior directed at any one particular individual. The conditions of extended supervision will include the following: maintain absolute sobriety, no possession of drugs or alcohol, you shall not enter any establishment where the primary purpose is the sale of alcohol. This will include places like bars, taverns, liquor stores, beer tents, and the like. You must complete an AODA assessment. You must comply with all recommendations of the Compass Assessment and the Department of Corrections. You must pay court costs and DNA surcharge on each count. You must submit a DNA sample. He may not have any contact with Isaac Schuman's family, including Elena and Danya Hernandez and Scott Schuman.
Fair.
He may not have contact with Alexander Martin, Riley Madison, Anthony Carlson, Dante Carlson, or Madison Cohen. He is responsible for restitution. The state must submit its restitution demand within 30 days. The defense may have 30 days thereafter to object. If there is an objection, the matter will be scheduled for a restitution hearing. Because Mr. Mui is convicted of serious felonies, he may not possess firearms. He may not possess body armor. He may not vote or hold public office until his civil rights are restored. If he were to do any of those things contrary to law, he would subject himself to additional criminal penalties. If he violates the no contact orders, he may also subject himself to additional criminal penalties. Does the state agree on the credit calculation, 732 days?
Yes.
All right, 732 days credit. Mr. Mui is remanded to the custody of the sheriff for delivery to the Dodge Reception Center. Is there anything else for today, Mr. Anderson?
No.
Mr. Nelson?
No, Judge.
All right. Thank you all. We stand adjourned.
$20 and then half a year basically of jail and restitution. So that puts him out at 75. I don't know if
Welcome
he
back
can.
to our Fox 9 streaming center. I
I'm
am
not
Paul
sure if he
Bloom.
can.
Of course, that
Oh, Lordy. Feels way too light. So disappointed with this judge. Yeah. 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 You know what? He's not doing very well. I doubt he's going to make 20 years in the Huskow. I doubt it. I mean, he's lost so much weight and he doesn't look healthy in any way, shape, or form. Yeah. Canada, well, life is life. And anything, life is not life. Life is 25 years. And anything other than that, they usually do about 2/3 typically. So yeah, very, very close. So guys, I am going to leave it there. It took them a while, didn't it? I wish we could have seen those victim impact statements. I would have liked to see what they all had to say. Maybe it'll come out. But I've got a busy day ahead of me. I just got 22 more documents on Stefan Stearns. So I'm going to go through that and might stream later today. So don't forget to hit the bell if you haven't. And I'm also looking still at what happened in the UK with those 3 little girls passing in Southport. There's a vigil that they held, and just basically an update is what I'm thinking about doing. So don't forget to subscribe, like, and share, and I'll see you guys soon in the next one. Bye.